No.
This is Rautre?
Yes, yes.
Okay, it's not great.
Yes, Justice Rautre.
Good one.
Supplementary list for admission, item number 1.
Before your lordship will take up this matter, Millers, in item number 1, there are all other matters which are connected with the first matter, PAL construction. These are all 2J matters, my lords. And item number 1, the first matter is totally different from all others. And your lordship may kindly see one order, that is order dated 3/11/2011 to 3/11/2021, passed in Dabur India case.
Yes.
My lord, second matter. That's second matter.
Second matter.
14069 of 2012.
That count as not placed.
Order dated 3/11/2021. My lord.
Yes.
Mr. Raghuvanshi is also appearing for the previous submitted. The question which has been referred to larger bench in WPC number 16957 of 2009, namely whether non-submission of audit visit report to the assessing officer within 7 days from the date of completion of the audit. The order is in fact a mistake, Mirror. That's the audit. Completion of the audit as completed under section 41(4) of the Orissa Value Added Tax Act renders the audit visit report invalid and assessment made on the basis of such audit visit report illegal is not praised by the present petitioner, that is Dabur India Limited. He praised therefore that this petition may be sent back to the Rostock Division bench for decision on merit. Result affidavit stated to file along with the filing process be brought on record. Accordingly, matter on 16/12, and now your lordship have adjourned to 6/4. Noting your lordship kindly.
Correct. So it's wrongly listed here.
All matters, Millers, except first one.
So all other matters are actually
6/4.
okay.
6/4/22, my lord.
All right.
In this case also, my lord, I may be permitted.
The first case, PAL.
PAL construction. That is also different. This will not come under this. As per your lordship's order, dated 3/11/2021.
Okay.
So this will come to their group along with WPC number 19127 of 2007 and 8484 of 2015. This will also not come under this group because they are on. We are on 41 and audit assessment, but they are in some other matter.
So this 19127 of 2016 and 8484.
Yes, ma'am.
The question is not about the audit visit report.
Yes.
No, it doesn't have to come to the full bench.
Yes, full bench.
Full bench.
Along with this matter, all these matters were listed.
Today they're shown.
Not shown. Not today list.
Those two cases, what my lord
So PAL plus those two have to be posted before the full bench. Oh, all right.
I beg this order.
Already, just in the first matter, you say already by an order dated 3/11/2021, it had been made clear that this petition had to be listed along with 19127 of 2016 and 8484 of 2015. It now transpires that although it had that by that order, full stop. You say, consequently, it is directed that the present petition with the aforementioned two petitions will be listed before the full bench on, we'll have it on some Thursday, sir. So should we do it for 31st March? This is Mahapatra?
Yes.
Oh, 31st March at 2 p.m. 31st March at 2 p.m. Thursday. And all the other matters, you say there is already an order passed by this court that these petitions should be listed before a roster bench, division bench on 6th April. That order is reiterated.
My lord, in PAL case, you have highly rejoinder also.
All right. Right, sir. Thank you.
Fine.
Right. This is Vishwanath Rath. Good morning, sir.
Sir.
Namaskar.
Supplementary
Sir.
list for orders, item number 1.
These batch of matters are the interest on refunds of sales tax, my lord.
Correct.
Lords, I have given the order sheet. to lords. Last
Right.
order I have given.
Mr. Mahanti, who has filed this application?
Your Lordship, I have filed this
has
application.
filed.
Department has filed this
How
application.
can you become petitioner in the application? See the cost title?
You have to be applicant.
Yes. And you have to make yourself as applicant, not by remaining as opposite party.
Correct. Correct.
Your Lordship,
Everywhere you are written petitioner approach.
Your Lordship, I'm extremely sorry, Your Lordship. Beg your pardon.
So these applications for modification by you.
Your Lordship.
Ah.
Your Lordship, these cases have been disposed of by
Yeah.
order dated 10th April 2019,
Right.
where this Honorable Court has perused the judgment of Honorable Full Bench, Your Lordship, in that Ideal Industries case.
Right.
And Your Lordship, in the finding part, Your Lordship, in the last paragraph of this order, in view of the direction of the Honorable Apex Court in paragraph 6, Your Lordship, that is this High Court in Full Bench, in paragraph 6 of the aforesaid reported case, the petitioner is entitled to interest on the refund from the date of assessment for the relevant year at the rate of 8% per annum till the date of payment. Your Lordship, in this case, we have filed the modification of the clarification of the order, Your Lordship. There are two assessments. Your Lordship, one assessment is
Provisional
the
and
original
final.
assessment.
Provisional and final.
Your Lordship, in the original assessment, there was a demand. And that demand has been subsequently reduced or deleted.
1 minute. Justice Ratha is saying something.
Mr. Counsel, when the deposit was made, interest should be drawn.
Correct.
Your Lordship, my lord has
Justice
already taken the
Ratha,
view.
Justice Ratha, I have taken the same view. I have taken the same view by an order of 14th March. So that is the order that he's showing us.
Your
Mr.
Lordship,
Mohanty.
my lord has already taken that view.
Yes.
Your Lordship, that paragraph 6, I should not argue again, Your Lordship.
Correct.
But only for one clarification, Your Lordship, that came to my mind, Your Lordship, if Your Lordship will permit me. That Sopara 6, Your Lordship, says, Your Lordship, within 1 minute, when a dealer is directed to deposit some amount as per the order of the High Court and the Supreme Court, he is entitled to get a compensation by way of interest on the amount of refund, ultimately calculated from such date as is directed by the said court. Your Lordship, this Sopara 6 may not be read isolated. That should be read along with paragraph 53. Your Lordship, shall I give a copy of judgment, Your Lordship?
All right.
Your Lordship, well, just for clarification, Your Lordship, I am not on the way, Your Lordship. Paragraph 53, Your Lordship. Your Lordship, what my submission is that when the direction has been made to deposit some amount, at that point of time, that direction should have been made. Your Lordship, paragraph 53, I have given the flag mark. Article 226 and 32 provide for safeguarding the provision. Your Lordship, just 4 to 5, 10 to 12 lines before, after, therefore, Your Lordship,
Yes.
therefore, considering the facts and circumstances of the case, and keeping in mind the decision cited by the parties, we are of the opinion that when conditional amount is directed to be paid out of a disputed amount, a condition may be imposed awarding interest from the date of such payment till favorable decision
But
is
that's what
given
we are
to the
doing. We are awarding interest from the date of payment.
Your Lordship, what my submission, when the direction has been made to deposit the conditional amount, this paragraph clarifies that. When that condition has been made by this Honorable Court under Article 226, in that order, that condition should have been made. Sorry.
He says, since there is no condition, we will not pay any interest. But there is
Then statute will come. That is a later on.
tendency of the REIT application. Therefore, it is always a conditional
Yes.
deposit,
All right.
subject to outcome.
Correct.
Your Lordship,
Justice Ratha, I think we both are on the same page on this. In fact, you say in view of the order dated 14 March 2022, passed by this court in Writ Petition Civil 3158 and 5222 of 2004, these applications by the department are disposed of by directing that the department will pay to each of the SSCs simple interest at 6% per annum on the amount of refund from the period beginning with the date of making the payment of the sales tax in the first instance till the date of actual payment, which shall not be more than 8 weeks from today. If there's any further delay than the above period in making the refund, the department will be liable to pay simple interest at 9% per annum of the said amount for the period of time.
Yes.
All right. All right.
Obliged.
Thank you. Thank you, Justice.
Your Lordship, it is very old matter. If can it be extended to some more period?
No,
Because
no,
It is
In
very
fact, it's an old matter, then you
Very
pay
old
earlier, the better.
Get fully.
All right. All right. Right.
I'm sorry, Your Lordship, I'm sorry. I should not have.
Namaskar, sir. Namaskar.
Supplementary list for orders, item number 1.
My lord, in this matter, I am the opposite party, my lord.
Mm.
Here the CBDT has filed a miscase before my lords
Mm.
for
Modification.
way of filing a miscellaneous application
Mm.
to modify the order of this honorable court,
Mm.
whereas the order of this honorable court has already upheld by the honorable apex court, and after a lapse of 2.5 years, they have filed a application in a miscellaneous application.
Anyway, let them,
Modify your
whoever has
exception.
filed the application, let them argue that first, sir.
Let the-
Let the applicant argue.
Yes, let the applicant argue first.
Am I audible, my lords? I'm sorry.
Yes, yes, you are.
Yes, you're audible.
I'm obliged, my lord. My lord, may I please have my application, which is CM 3553 of 2021, in which my lords are pleased to issue notice.
Correct.
My lord, this is an application which my lord will see has been filed for a very limited purpose, because in subsequent proceedings, and this is the reason why, my lord, it was necessitated that we file this application. In
Yes.
subsequent proceedings where gratuity has been withheld on account of a completely different criminal proceeding pending, which we are entitled in law under Rule 69 to do
Correct.
so, and there are several Supreme Court
So
decisions.
the order of this court will not come in the way of your withholding that gratuity for the criminal case.
That's the limited point. For the reason my lord will see, and I'll make good my submission.
Yes.
Page 34, annexure A1, which is the CAT order. The CAT order is what was finally being upheld by this honorable court in the writ proceedings in a writ filed by us, my lord, the CBDT.
Right.
At page 42, the CAT was careful in saying, my lord, if my lords have page 42, the
Yeah.
Yes.
the fourth last line from the bottom, my lord,
Right.
the respondents are directed that if they have withheld the retirement dues of the applicant because of the present charge sheet.
Right.
Present charge sheet, my lord will see 3 lines above, was the charge sheet dated 29th April 2009.
Correct.
There is no justification to continuing withholding the retirement benefits. Then the very next page, my lord, is the order of this honorable court and the writ filed by us. My lord,
Right.
under no principle of law could we have been worse off in our own writ.
Right.
The worst scenario for us, my lord, was that the CAT order being upheld, which was done. And
Correct.
my lord will see also the manner in which it was upheld. Page 46, bottom, my lord.
Right.
The
You're
honorable
in complete agreement. Yeah.
complete agreement with the CAT's. So, my lord, the sentence thereafter, retirable benefit cannot be withheld on the ground of mere pendency of criminal proceeding. Even assuming this is not modified, it can only be clarified to say it could have only related to that present charge sheet of 29th April. That's my
No. Correct.
And
What do you
my
say? Yes.
only one
What do you say?
point.
Sorry.
Learned friend says, my lord, that SLP is dismissed. My lords, Kunni Ahmed's dismissal simpliciter of an SLP does not attract Article 141 or merger. That also I've placed on record with this, my lord.
Correct.
So I'm obliged, my lord.
Yes,
My
Mr.
lord, my lord, only I place 46, that is your lordship's order.
Correct.
They have already forget to place the second 3 lines, my lord. In view of the above, we are in complete agreement with the view taken by Law and Tribunal, which is just and proper. Retirement benefit cannot be withheld on the ground of a mere pendency of a criminal proceeding. If on conclusion of the criminal proceeding, the opposite party is convicted, then it can be recovered from his
No,
pension.
but the charge
have
sheet
also
we were
given-
talking of, sir, the charge sheet which was being spoken of at this stage
My lord.
is a different charge sheet.
Yeah, exactly.
Huh.
It's a different
It's a
charge.
charge sheet of 29th. See, 29th April 2009 charge sheet which was being talked of. Not the charge sheet which they've referred to in the present application. That's a
Yes.
different charge sheet.
My lord, there were two charge sheets against the petition.
Correct.
One is a criminal charge sheet, which is under track. Another is departmental proceeding basing on that. Is a
So this
procedural charge.
29th April, which stood quashed, was the departmental charge sheet
The departmental charge sheet has been quashed by the Law and Tribunal.
and have been
Yes.
fully approved by this court.
Man,
So there was no occasion to talk of the criminal charge sheet at all, sir. That was not in the scope of the petition
the
also.
department has in his read petition, they have told that so there is a criminal proceeding against
No,
him.
no. So the
That's
scope,
not-
no, no.
has
the
come to
scope,
conclusion.
the scope of the petition was only the civil disciplinary charge sheet.
That
The
is-
scope was
no,
not
my
the
lord.
criminal charge sheet.
No, only these criminal things will arise before this court because the department has mentioned in their read petition there is a criminal case pending against him. That's
No,
why
no,
this
this,
court
this
has come
court,
to a
this court
conclusion.
cannot,
Even if the
Mr.
criminal
Patnaik, the court cannot go beyond the scope
Correct.
of the application.
Correct.
My view is that if a criminal proceeding is going on 30 years, 40 years.
That is a different thing. That is a
That's
different
different
thing.
thing.
the court-
You
court has
might
given
file a
direction.
criminal revision case to expedite that. That's a different thing altogether.
You have
That's why
you have a separate remedy for that.
Yeah.
Rightly hold that if the amount is paid to him, he is giving undertaking
No, no, but
to repay the amount.
not in this
for 60
petition, sir. In this petition, there was no scope of saying what should happen if the criminal proceedings culminates in an acquittal and all. There was no scope. This is not the scope of this petition at all.
Then
In
this
their
case is going to
application,
the
the relief
Supreme Court
cannot
by
be
the
granted to
department.
you.
Yes.
Then this case is going to Supreme Court by the department.
Correct.
And the Supreme Court has already been narrated in the order in the last line.
Yes.
However, the question of law is kept open to be
Correct.
asked in
Correct.
an appropriate case.
Correct.
In an appropriate case.
No, no. So
By this-
all that is in the context of that civil disciplinary proceeding, sir. It was not in the context of a criminal case.
Sir, even if it is so, my lord,
Right.
even lapse of more than 2.5 years,
Right.
how that is a miscase is lie in this court.
All right. All right.
So
All right.
miscase cannot be,
They don't want to be in contempt, sir. That's why.
there is no provision at all
All right, sir.
to file a miscellaneous application to review your lordship's order. So he cannot file a review application instead of that
No, again-
miscellaneous application.
All right. All right. You say the present application by the Union of India seeks a clarification oblique modification of the order passed by this court on 7th March 2019 in writ petition civil 19169 of 2018. Paragraph. The aforementioned writ petition had been filed by the Union of India in this court, questioning an order dated 22nd November 2011, 22nd September 2011, passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack, bracket CAT, in OA number 447 of 2010, filed by the opposite party. Paragraph. The subject matter of the aforementioned application, OA 447 of 2020 before the CAT, was disciplinary proceedings initiated against the opposite party by a charge sheet dated 29th April 2009. Full stop. For the reasons stated in that order, the CAT quashed the said charge sheet and in the operative portion held as under. Now take from page 42 of this application, the line beginning, in view of the quashing of the charge and all other orders, up to released forthwith. Paragraph. When the above order of the CAT was challenged before this court by the Union of India, this court, in its order dated 7th March 2019, declined to interfere, expressing complete agreement with the order of the CAT. Full stop. However, in doing so, a further observation was made in the order of this court that retirement dues, retirement benefits cannot be withheld, open quotation, on the ground of mere pendency of criminal proceedings, unquote. Full stop. The operative portion of the order of this court reads as under. Now take from 46 bottom till 47 top. Paragraph. The Union of India then questioned the order of this court by filing SLP Civil diary number 2979 of 2020, which came to be dismissed by the Supreme Court on 14th February 2020 by the following orders. Now, reproduce just the order portion from page 106, paragraph. The occasion to file the present application has arisen in view of the fact that in a separate FIR number, FIR dated 18th April 2005, in RC number RC 19 bracket A oblique 2005, criminal proceedings initiated against the opposite party is still pending. So it is explained in the present application by the Union of India that by virtue of the pendency of the said criminal proceedings, which is for the commission of an offense under section 13 bracket 1 bracket small e read with section 13 bracket 2 of the Prevention of Corruption Act 1988. The Union of India is authorized to withhold the gratuity in light of Rule 9 read with Rule 69 of the CCS bracket pension bracket rules 1972. Full stop. Rule 9 of the CCS bracket pension rules 1972 reads as under, take from internal page 8 of the application, para 10. Rule 69, which talks of provisional pension, reads as under, take from para 11 of that application. Paragraph. It is clarified that while payment of gratuity to the opposite party has been withheld, all other retirement benefits have in fact been paid. Full stop. The tabulation of the payments has been set out in para 12 of the application. Paragraph. Reliance is placed by the applicant Union of India on the decision of the Supreme Court in State of Orissa versus Kalicharan Mahapatra, 1995 6 SEC 105, to justify the withholding of retirement benefits pending the final disposal of judicial proceedings. Full stop. It is accordingly submitted. Reliance is also placed on the decision by case Singla versus Punjab National Bank, 2013 3 SEC 472. Full stop. Mr. Zohaib Hussain, learned counsel appearing for the Union of India, accordingly submits that this court should clarify the observation in the operative portion of its order dated 7th March 2019 to permit the Union of India to continue withholding the gratuity amount pending the outcome of the criminal proceedings, aforementioned criminal proceedings. Paragraph. Mr. J.M. Patnaik, learned counsel appearing for the opposite party, however, contends that once the Supreme Court has affirmed the order dated 9th March 2019 of this court, 7th March 2019 of this court, by dismissing the SLP filed thereagainst, there is no scope for the Union of India to file a further application for clarification. The opposite party being convicted then the payment made can always be recovered from his pension, and therefore no prejudice would be caused to the Union of India. Full stop. He also questions the maintainability of the application by the Union of India. Paragraph. Having considered the above submissions, the court would like at the outset to observe that the settled legal position is that the mere dismissal in limine of a special leave petition by the Supreme Court against an order of the High Court would not ipso facto amount to concurrence with the view of this court on merits. This stands clarified in a series of orders of the judgments of the Supreme Court, including this is the latest is Bharat Amritlal Kothari. Mr. Hussain?
Yes, my lord, Kunya Ahmed would be the first.
First one. Which page is that?
That is, my lord, I have given reference of it at page 25.
Because you've annexed this other judgments of Union of India versus R. Tyagarajan and all that.
Yes, my lord. Yes, my lord. I'll just. My lord, Bharat Amritlal is a judgment on the proposition that a relief not prayed for cannot.
Right. Correct.
That is something else, my lord. At 29 is Kunya Ahmed, 2000, volume 6 SCC 359. Merger does not apply even if it's a dismissal simpliciter.
Correct.
That unfortunately may not be placed, my lord, but I've given.
No, that's okay. You say, as explained, including Kunya Ahmed versus State of Kerala, 2006 SEC 359. Full stop. Consequently, this court negatives the plea of the opposite party that the present application seeking modification or clarification of the court's order dated 7/3/2019 is not maintainable on the above scope. Paragraph. The scope of the petition before this court, before the CAT, and consequently of the writ petition before this court were the disciplinary proceedings and the charge sheet issued against the opposite party in those proceedings. To stop, the scope of the proceedings did not include the criminal proceedings against opposite party initiated under the PC Act. Full stop. Therefore, any observation concerning such criminal proceedings was outside the scope of the writ petition itself. Full stop. There is merit in the contention of the applicant Union of India that the scope of the orders of this court have to be understood as being limited to the subject matter before this court. The said proposition finds support from the decision of this court, of the Supreme Court, in Union of India versus R. Tyagarajan, right?
Yes, my lord.
2025 SCC 201. Full stop. When this court expressed complete agreement with the order of the CAT, it was obviously concurring with the view of the CAT that the charge sheet against the opposite party in the disciplinary proceeding should be quashed. Full stop. There was no occasion, therefore, for the court to deal with the outcome of the criminal proceedings, which was not the subject matter of either the petition before the CAT or the writ petition in this court. Full stop. Consequently, this court has no difficulty in clarifying that the aforementioned observations of this court in its order dated 7th March 2009 would not preclude the Union of India from proceeding to withhold the gratuity on a reading of Rule 9 read with Rule 69 of the CCS pension rules, pending the outcome of the criminal proceedings aforementioned. Full stop. The application is disposed of in the above terms.
Obliged, my lord.
All right. Right, sir. Thank you, sir. Thank you. Yeah.
Sir,
Yes, 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 sir.
Supplementary list for orders, item number 1.
Permitted to mention on behalf of Iqbal Savia, my lord, they have already filed rejects, my lord. In WPC number 21230/2012 on 24th of January.
All right. Requisites have been filed.
Yes, my lord, on 24th of January you have filed, my lord.
Not filed, it says, sir.
What the receipt, my lord? On 24th of
Sir,
January.
you are appearing for the.
Lordship, I am appearing for the second writ petition, that is WPC 3569.
Anyway, same UCO bank would be.
Yes, Lordship.
You are the same party.
But in the first writ petition, that was disposed of.
No, he has filed this application for modification.
Yes,
Ah.
that is there. I am challenging here the Lordship.
No, let him argue his modification application then.
My lord, in this particular case, your lordship is directed to place it before the appropriate bench on order dated 7/12/2021. And according thereafter, the case was posted before the appropriate bench and the order was passed to issue notice to the UCO bank. And another matter, the notice was issued that they have to implement the auction purchaser as a party. They have not taken that step.
Whom are you for, sir?
I am for the UCO bank.
You are also for UCO bank.
No, he is in the second.
I am in the
application.
second writ petition
For whom?
for petitioner.
So, okay. So, all right. Yes, so you argue why you want the modification.
That
is
last occasion, in my writ petition, the bank has, as the interim order, we have not deposited the amount. But actually, we have deposited the amount, my lord, and we have, in my, I have filed the receipt that we have deposited. By submitting falsehood, my lord, they have obtained the dismissal order.
What do you say to that?
My lord, in that case, particularly the interim order was passed on 15th November 2012 till 16/12/2012. And in the meantime, they had to deposit 1,60,000.
Right.
Admittedly, as per my instruction, they had I had mentioned that they have not deposited 1,60,000, but in fact, they have deposited 1,60,000. But after 16/12/2012, the case has not been listed and never they have
But
deposited.
we had vacated the stay only because you said they had not deposited, sir.
No, my lord. In that case, in 2021, it was listed. And from 2012, the order has already been expired. Till 2012, 16/12/2012, order was there. Thereafter, no extension of stay was there. Admittedly, they have deposited the amount that
So in para 3, you recorded your statement. It is also stated that he is not deposited.
No, my lord, that is not a proper instruction. On instruction, I could verify.
So what we'll do is, now what has happened? We have sent the matter back, or
no, my lord. What has happened in the meantime? The after dismissal, the property has already been sold. Then the auction purchaser has already deposited the entire amount, and sale confirmation has been made on 24/1/2022. The property has already been sold.
My lord, by submitting false court, they have obtained the dismissal order, my lord.
so you are not in possession anyway, sir.
Yes, my lord.
So
You want to challenge that, my lord? That
on
is
that day also, my lord, on that day, particular day, the petitioner was also absent when the case was dismissed.
no, that's right.
Yes, my lord.
That's right. But the statement was an incorrect statement, sir.
Incorrect statement to the extent that they have not deposited 1,60,000.
That's right. We vacated the stay only because he made that statement.
No, my lord. The stay was already till 16/12/2012.
Whatever, sir.
Conditional order.
So the question was, because you said he did not make the payment, he vacated the stay. Now see, after vacating the stay, you've quickly moved to have the property sold. You've sold it.
No, March after, my lord. March after, in the month of November.
Much.
In the month of April, order was passed. In the month of November, we went for sale.
Oh, I see.
March after.
Oh.
In that period, they have not.
What is
taken
your explanation, Mr. Guru?
No payment.
Why did you remain absent when the matter was listed, and why did you not immediately move?
My lord, due to this corona, my lord, we didn't get, for which we could not.
No. And you've actually not been appearing in the DRT. That's a fact.
That's a fact. On the question that the stay is continuing, they are not appearing. And they have not made any payment in the meantime. From 2012 till to, November.
Right.
Not a single rupee has been paid after 1,60,000. And the outstanding is now almost, as per their statement, 57 lakhs some odd. Along with interest from
Their action, my lord, their action is illegal.
Meaning?
They have falsely stated before this honorable court to get the stay vacated.
No. See, the fact, there were two reasons why they wanted stay vacated. One was that you were not appearing in the DRT at all.
Yes, my lord.
So there was no, see, we did not stay proceedings before the DRT. We only said no coercive steps will be taken against you.
Hello.
So that was not a license for you to just stay absent from the DRT altogether.
I bogged down, my lord. The fact remains that due to because of their false statement, the stay has been vacated, and thereafter they have moved fast to.
See, one, Mr. Guru, only one possibility exists. Whatever money they have collected by way of auction sale, that can be kept in the fixed deposit and will be subject to the orders of the DRT. All right.
Sir, may I say?
Yes.
Sir, in the connected matter, after the subsequent development, this particular petitioner, the same petitioner has filed another writ petition, wherein some order has been passed by the regular bench.
Okay.
That is connected here.
Right.
So we can say that in view of, though there was an order passed on 26/4/2021, which is seeking for recall, but in view of subsequent development that the property has been auctioned, and the auction purchaser has been, and the matter is now challenged in another writ petition.
Right.
There will be no fruitful purpose in recalling that order.
And we can also dispose of the main writ petition itself.
Main writ petition we can dispose of?
Correct.
With the Mr. Guru, 1 minute. Sir, the main writ petition has been dismissed.
Correct.
That we will not disturb, saying that in view of the subsequent development that the property has been auctioned and the same has been challenged in the connected writ petition. Therefore, no fruitful purpose will be served by recalling the order. That we can say.
Correct. No, the main writ petition is still pending, sir.
No, sir, main writ petition is dismissed, sir. This is paragraph 4 of order dated 26th April 2021, order number 4. Paragraph 4, last line.
April?
Yes, sir.
No, there are only five paragraphs.
Paragraph 4, na, sir?
Oh, the writ petition is dismissed. Correct. All right. You're right.
The thing I want to mention, my lord. On our IA, the petition was dismissed. They have not appeared. They have not taken any.
No, I know. All right.
On the bank's initiative, it was
the present application. All right. The present application by the.
May I interrupt?
You have nothing to say in the main.
After the dismissal of the main writ petition, the IA was filed by the petitioner, same petitioner, that for the recalling that order, also for the modification of that order. So that is pending, Miller.
No, that is what we're dealing today. Right now, we are going to pass order in that IA only, sir. Right now, what your order you're going to hear is the order in that IA. All right.
That was filed before the auction.
Whatever, sir. Whatever. No problem. You say this IA has been filed seeking modification of the order dated 26th April 2021 of this court, whereby while vacating the stay order dated 15 November 2012, this court dismissed the writ petition civil 21230 of 2012. The above order was passed in IA number 4663 of 2021 filed by the UCO Bank, which had submitted to this court that the present petitioner was not appearing in the proceedings before the Debt Recovery Tribunal, like a DRT. And further, that the petitioner had also not complied with the conditional order of stay, requiring him to deposit rupees 1,60,000 with the UCO Bank. Recording the above submission, the order dated 26th April 2021 was passed by this court. Paragraph. In the present application, it is pointed out that the petitioner had in fact tendered the sum of rupees 1,60,000 by way of a banker's check dated 15/12/2012. And therefore, a wrong statement had been made by the UCO Bank before this court, on the basis of which the above order was passed. Paragraph. Counsel for the UCO Bank does not dispute the fact of the petitioner having paid rupees 1.6 lakhs by way of a banker's check on 15/12/2012, and therefore is candid that the statement made before this court to the contrary was in fact incorrect. First of all, however, he points out that the petitioner in fact did not appear before the DRT in the pending proceedings against him, and also did not make any further payment after 15th December 2012. Stop. Mr. Guru, learned counsel appearing for the petitioner, does not dispute the fact that the petitioner has not appeared before the DRT and has also not made any further payment. Paragraph. The court is apprised of certain further developments that have taken place in the meanwhile. Paragraph. After the stay was vacated by this court on 26th April 2021, the property in question belonging to the petitioner was brought to auction sale, was sold in a public auction. The auction purchaser and possession of the sale certificate was issued in favor of the successful auction purchaser, who also has been put in possession of the property in question.
No. He is not in possession.
Sale certificate has been issued.
Has been issued on 24/1/2022.
On 24/1/2022. Full stop. However, the auction purchaser has not been put in possession of the property in question. Paragraph. The proceedings are continuing before the DRT. Full stop. Questioning the auction sale, Writ Petition Civil 35691 of 2021 has been filed in this court. And the matter is pending before the roster bench, and certain orders have been passed in that writ petition. Paragraph. Keeping in view all of the above developments, the court is not inclined to recall its order dated 26th April 2021, but clarifies that this order will not come in the way of Writ Petition Civil 35691 of 2021 being decided on its merits. Full stop. Since all the issues that have been raised in the present application will be considered in the said writ petition, the court does not consider it appropriate to revive Writ Petition Civil 21230 of 2012. Full stop. With the above clarification, the application is disposed of. Right.
Supplementary list, fresh admission, item number 1.
May I please, Lordship? Not in part that institutional integrity was the subject matter in this writ application, Lordship. But now, Lordship, kindly see only perhaps one prayer survives, Lordship. That is, kindly come to my prayer. That is prayer number 3, Lordship. Page 32.
All this is too broad sweeping.
But Lordship, kindly see page 65 for a moment.
Yes. This has to happen through parliamentary procedures, sir. We can't in the court direction.
No, in fact, Lordship, it is legislature, Lordship, because it's state
Correct,
legislation.
correct. It's for the parliament or state legislature.
But Lordship, the directives by the Naval Apex Court, Lordship, in several judgments, institutional integrity must be there, Lordship.
No, but let that happen. There are enough judgments of the Supreme Court on that.
But Lordship, for a moment, just I want to draw, Lordship, kind of Annex 4, Lordship, that is page 65.
Yes.
What manner they are doing, Lordship, kindly see. Lordship, last election we have seen, Lordship, what they have done. By this, but because only they are getting the IS officers only to hold this post, Lordship, kindly see, class 3, Lordship. No person shall be qualified being
even
commissioner.
your chief election commissioner is only an IAS officer. Members of the election commission are invariably IAS officers.
Lordship, kindly see class 3. The rules they have done, Annex 4.
Yes.
Miller, the first class, a retired judge of High Court.
Yes.
A retired district judge. Then Lordship is comes to civil post, Lordship.
All right.
But now, Miller, the date of legislation now, IS officers are only holding this post, Lordship.
All right.
Had it been, Lordship, any impartial, Lordship, what they are doing, Lordship, kindly consider, Lordship. Last election, Lordship, have seen. They have ignored the entire tribals, Lordship.
We can't.
And they are coming up.
We don't get into all that, please, because these
but
are not these are all highly disputed questions.
But Lordship, only Lordship say, because in the meantime, Lord, because the very good matter that I have, because by a flux of time, it is time has barred, Lordship.
So you be alert, have these petitions listed in good time, then it will have some purpose. It will serve some purpose.
In fact, I was trying my best, Lordship.
No. All right. With passage of time, the prayers have been rendered infructuous. As far as prayer number 3 concerning the selection procedure for appointment of a state election commissioner, the court leaves it open to the petitioner to raise it in appropriate proceedings, in separate appropriate proceedings in accordance with law. The petition is disposed of. All right.
Disposed of, Lordship?
Disposed of.
Supplemental list, item number 2.
The matter has been listed on 19th/4/2002. All matter.
No. I think you're in. No. Item 2 is different, sir.
Other connected matter has already been disposed of in this case. Item 2, my lord.
Which is that order?
Highly attached. The other case rejected. 2 cases are there in
the records are there.
Records are. Probably rejected.
You say in view of the judgment of the Supreme Court. Oh, these are the candidate peons.
Yes, my lord.
In civil appeal number 979 of 2014, Renu versus District and Session Judge C. Cesari. No, the relief prayed for is not capable of being granted. The petition is disposed of. Right.
Supplementary list, item number 3.
Yes, Mr. Chairman.
Same matter has been listed on 19th April 2022.
Okay, list on 9th April 22. Right.
Supplementary list, item number 4.
Same, my lord. They are fixed on 25th March 2022, where Justice K.R. Mahapatra is there.
All right. List before a bench of which Justice K.R. Mahapatra is a member on 25th March 22.
25th March.
All right.
Supplementary list, item number 5.
May I please, my lord?
Yes, yes, please.
My lord, here the petitioner challenged the notice under section 148, hide annexure 1, page 16, where approval has been given by the JCIT, not by the state and commissioner.
Oh, so it's covered.
Yes, ma'am.
All right. In the present case, the challenge is to a notice under section 148 of the Income Tax Act 1961, Bracket Act, which has been issued after approval by the JCIT and not the CIT. Full stop. On this short ground, comma, following the order dated so-and-so of this court in so-and-so.
24th January.
Yeah.
24th January.
If you notice is quashed, the writ petition is disposed of. All right.
All consequential proceedings.
On writ petition, the notices and all consequential proceedings I have quashed. All right.
Obliged, ma'am.
Supplementary list for orders, item number 6. Special admission, item number 6.
May I please, Your Honor?
Yes.
Here, my lord, as per the advertisement at Annexure 1, it was floated in the May 2019, my lord, for the post of 4 categories. One is junior clerk cum typist, junior typist, stenographer, and salaried domain, my lord. And the petitioner is the aspirant candidate for the post of junior clerk cum typist, my lord. I have applied for the post. The entire examination is of 3 parts. Part one is written test, the second one is computer test, and the third one is viva voce. My lord, so far the second is concerned, computer test, my lord. There I have though appeared, but the result was found that it was.
When did all this happen, sir? When did all this happen?
My lord, this happens in date of advertisement of 2019, my lord. The result was published on 20/12/2020, my lord.
2021.
Yes, ma'am. No, my lord, 2020.
Then why have you taken 2 years to 1.5 years to
My
file?
lord, fact remains, I don't have any document. I have sought for under the RTI Information Act. Then I have sought for the information of this result sheet, my lord. So for the group A, B, and C is concerned. In the first information, my lord, I have been supplied.
What is the ground? You want revaluation of your answer sheet?
My lord, that has not been taken into consideration, which has been well admitted by the authority that the group B answer sheet, it has not been taken into consideration. Kind of a glance to page annexure 7, my lord. For a moment, my humble submission. It is at annexure 7, page 42, my lord. When in RTI information, it has not been supplied. So for the A, B, and C is concerned, only A group and C group was supplied. Then I preferred the appeal. In appeal, order was passed under annexure 6 at page 40. Therein, for the first time, the authority expressed that the group B examination sheet, it was submitted in late, my lord. When A, B, C, it is for 1 hour, my lord. My humble submission would be, at the same time, it is all the way it has been collected. But the for first time in the appeal, they have said that A and C has been supplied and B has been supplied in the late, my lord, the answer sheet.
So how does one get into that side? It will become a disputed question.
Exactly, my lord. That is group B. Kindly have a glance for a moment at page 43, my lord. Page 43 is the information sheet of group B result, which has been supplied to me in the appeal. Therein it has written that answer given beyond time, my lord.
Correct.
Which is practically not possible, my lord, because it is 100 marks. The system is of A, B, and C, but in one time it has been collected. When A and C is available in time, B is beyond time. That what it has been written. But no time has been specified so far this signature is concerned.
If you want, they can file an affidavit how this is beyond time. You want to file an affidavit on that? Mr. Mudali states that an affidavit will be filed.
Or your lordship may direct that page 45, the representation, that is also pending, my lord. That can be disposed of.
All right. You say the petitioner's representation to the District Judge Cuttack, dated 26 July 2022.
21. No, my lord, it's 21.
21. Be examined and a reasoned order thereon be passed by the District Judge, not later than 9th May 2022. and be communicated to the petitioner not later than 16th May 2022. The court clarifies it has not expressed any view on merits. The petition is disposed. All right.
Supplementary list for orders item number 7.
None appears dismissed or not.
Supplementary list item number 8.
All right. Counsel, the petitioner states this has become infructuous.
And similarly, item number 26 also infructuous.
All right. 26 also.
26 also.
All right.
SS Mahapatra appearing for the opposite party.
All right, sir. All right.
Supplementary list item number 9.
Transport matter.
Item number 9.
Nine.
I have challenged the action of this RTO charging 300 rupees per month for renewal of the license.
This additional fee of 300.
Renewal of the fitness certificate of the vehicle.
So this is covered, I think.
Yes, it's covered.
Same order.
It's covered.
Same orders. You annexed the order, sir?
Not on.
Or the transport orders, there are same orders. All right.
Supplementary list item number 10.
OA transfer.
Usual order. OA transfer.
Supplementary list item number 11.
None appears dismissed. No.
Supplementary list item number 12.
I have already served the copy on the government council and the defect they have shown.
What is the matter, sir?
This is, Malla, kindly have a glance to page 6 of the revision. The earlier noble code to dispose of my representation, this has been rejected under Annexure 5. I have challenged the Annexure 5. For promotion, my lord. I'm the senior clerk in the Koraput district, my lord. Another Koraput district judge. But I have not been considered for promotion. My juniors have been promoted.
Lordship, may kindly see page 38. The part of impugned order
from SC category. So the reasons are given, page 38.
My lord.
Just read it after detailed deliberation.
After detailed deliberation and scrutiny of these CRs, the present performance report and service books of the committee found that no adverse remark has been passed against any of the employees noted except the Muralidhar Behera, senior clerk. And the committee also observed that Muralidhar Behera had been proceeded departmentally 4 occasions during the limited period of service. DP number 4 of 97, DP number 3 of 99, DP number 3 of 209, and DP number 2014 for disobedience of the authority by leaving headquarters without permission, availing leave without sanction of the authority, false statement and representations, recklessness, non-put up of records, multiplication of the date of the case record, non-compliance of the order, and was imposed and major punishment. That apart, he has kept under observation by the department review committee for a period of 1 year. The punishment period of Sri Behera, all the 4 departmental proceedings has already been completed. The departmental promotion committee, while pursuing the present performance report of Sri Behera, found that the present performance report was also not satisfactory as reported by the presiding officer concerned. Accordingly, the committee, taking into the account of the CCR, previous service record and the present performance report, arrived at a consensus that Sri Behera was not fit for promotion to the higher post at this time. I'm challenging that.
Nothing wrong with this order, sir. What is wrong with this order?
After being deputed to the permanent Lok Adalat for 6 years, he was returned and was posted under the new court, that is Women's Court. And within the fortnight, the report was called for from the PO about the performance report, my lord. Not from the previous PO, but from the present PO, who was joined for just 2 weeks before the
That's
date of.
No, but there's a past, your CCRs were looked into, sir. There have been past instances. Promotion is not a matter of right. You only have a right to be considered for promotion.
My lord, all the period they have imposed penalty, that has been over for last more than 6 years, my lord.
But still, they have to make an overall assessment, sir. There are other 4 people in the fray. They have to make an assessment. Who's suited for promotion?
And with the, in the recent past, there is no adverse remark, my lord.
No, that's okay, sir. That's
last remark was 2014. And the
still,
promotion.
Yeah, still, sir. You say this is the second round of litigation concerning the grievance of the petitioner about his non-promotion to the post of head clerk in the district judgeship of Koraput. Earlier, the petitioner had filed writ petition civil 29830 of 21, which was disposed of with this court by an order dated 25th October 2021, requiring the petitioner's representation to be examined and disposed of by the district judge by reasoned order. Paragraph: pursuant to the above order, the district judge Koraput, Jaipur has on 3rd January 2022 passed a detailed order rejecting the petitioner's representation. Full stop. Accordingly, the petitioner has filed the present petition challenging the said order. Paragraph: this court has heard the submissions of Mr. K.C. Guru, learned counsel, the petitioner, and Mr. P.K. Mudali, learned counsel appearing for the opposite parties. Paragraph: a perusal of the impugned order reveals that in the scheduled caste category, scheduled caste bracket SC bracket category to which the petitioner belonged, there were 3 candidates in the fray for being considered for promotion to the post of head clerk. Full stop. As far as the full stop, all their character confidential roles, present performance reports, and service books were examined. Full stop. Were examined by a departmental promotion committee bracket DPC. Full stop. The impugned order notes that the DPC found no adverse remarks against the other 2 candidates. But as far as the petitioner was concerned, it was noted that he had been proceeded departmentally on 4 occasions. For various reasons, including leaving headquarters without permission, availing leave without sanction of the authority, false statements and representations, recklessness, not putting up records, manipulating date of case records, non-compliance of orders. Full stop. The petitioner had also been awarded major punishments. Full stop. It was found that the present performance report was also not satisfactory. Full stop. Paragraph. Mr. Guru submits that the present performance report was called from a judicial officer with whom the petitioner was working only for about 6 weeks prior to the submission of such report. And therefore, the procedure adopted was unfair. Full stop. The court notes that the decision of the DPC was not dependent only on the present performance report, but on an overall assessment of the past record of the petitioner as well. Paragraph. Having examined the impugned order in light of the submissions made by Mr. Guru, learned counsel to the petitioner, the court is not satisfied that any case has been made out for interference with the impugned order of the learned district judge. While the petitioner could insist on a right to be a right to be considered for promotion, comma, the petitioner cannot claim any right to promotion as such. Full stop. The criteria of suitability is relevant in the context and the assessment of the DPC about the petitioner's non-suitability for promotion.
Rule 11
does not call for any interference.
The criteria for promotion is merit and suitability.
Right.
With due regard to that is Rule 11 of the Odisha District and Subordinate Court Non-Judicial Staff Service Method of Recruitment Conditions Service Rule 2008.
2008, is it?
Yes.
Okay. All right. Petition is accordingly dismissed.
May I pray one thing, my lord?
Yes, please.
They have mentioned that the is not fit for promotion to the higher court as this juncture, my lord. His candidates may be considered in future. With
So
that,
that anyway will happen. So you are challenging this, so we are passing this order. All right.
with that objection, my lord, I pray for
Sorry?
that the petitioner's promotion in future may be considered.
No, then withdraw this petition then. You can't argue all this and expect us not to say anything, sir.
Because in the report, they have already stated that they are not fit for promotion to the higher post at this juncture. My apprehension that the
No. So you have to make up your mind. See, we have to deal with your contention, so we have dealt with it.
they may not consider for future, my lord. That's the only apprehension, my apprehension, my lord.
We can't anticipate what they will do in future, sir.
They have clearly stated that they are not fit for promotion to the higher post at this juncture.
Then, so you leave it at that, then you should not challenge it.
Because this will come to across.
So you make up your mind, Mr. Guru. We have passed the order. If you want to press this petition, this order will remain. If you think this order will come in the way if you are being considered for the future, then say you are not pressing the petition.
Yes, I'll withdraw the.
All right. Counsel, the petitioner seeks leave to withdraw this petition. Dismiss is withdrawn. All right.
Supplementary list item number 13. Supplementary list item number 13.
Done. Okay. Just pass it over once.
Supplementary list item number 14.
May I please, your lords, I may be permitted to withdraw the writ petition. That is certain fact I have to.
All right. Counsel, the petitioner seeks
With
leave
the
to withdraw
liberty
this
to file
petition
it
with
as
liberty
is.
to file a better petition in accordance with law. This post office withdrawn with liberty is free.
Supplementary list item number 15.
Lordship, item 15, this is the second round of litigation, Lordship.
Yes.
My lord had previously directed the opposite party number 1 to dispose of our representation and to intimate the same within 28 February, my lord. My contention was that to increase the upper age limit as per the GA department notification. Lordship, as per page 34, they have rejected my representation, my lord. And they have cited that the Honorable Court has opined that my representation and considering my application is not feasible. Only single word has been assigned in the speaking order, Lordship. Page 34 is the rejection order.
Yes.
My lord, recently in the Supreme Court in the High Court of Delhi versus Devina Sharma has upheld the decision of the Delhi High Court in increasing the upper age limit in the DJ's examination, Lordship. And being a beneficial statute, Lordship, beneficial rule, which is applicable for the recruitment for 2021, 22 and 23, I should not be deprived of this benefit, Lordship. So a liberal approach must have been taken.
I think we have.
My lord,
in Delhi, that Supreme Court case, what my learned friend is saying, Milord, that judgment is not applicable to the present case. In Delhi, what has happened, Milord, in 2019 and 20, the examinations were not held. So therefore, those petitions,
So it was
the
not
judicial examinations,
COVID related.
Yes, Milord. In this case,
but my lord, the GA department notification has.
But I'm coming to it. Milord, so far as GA department notification is concerned, that is at page 13, Milord. In that page, Milord, the Orissa Civil Service Fixation of Upper Age Limit Rules 1989 was amended, and the SCBC candidate age was enhanced for 5 years. But Milord, in Orissa Judicial Service Rules, Rule 18 says about the age of and that rule has not yet been amended, Milord. Now, OJS exemptions are conducted under these rules, OJS rules of 2007. That rule has not been amended. And that letter, the impugned letter, in which the additional secretary law department has stated that after the discussion with the High Court, these relaxations cannot be granted. Because Milord, because that also, Milord, these people also will see section 40, rule 47 of Orissa Judicial Service Rule 2007. They say that where the government, in consultation with the High Court, is satisfied that it is necessary or expedient so to do, it may by order for reasons to be recorded in writing, relax any of the provisions of these rules with respect to any class or category of persons or post in the service. So therefore, the law secretary must have consulted with the High Court, and after the consultation, he found that this relaxation cannot be given to the petitioner.
But in the lordship, in the reasoning part, they have only stated that it is not feasible.
No, because the rule provides it.
Like my lord knows that a speaking order must state the grounds for rejection or acceptance.
But that is not. Lord, the petitioner will also kindly visualize one thing. Lord, the petitioner is now 42 years old. Lord. Is now 42. Now 30. He was given. Lord, I was also seeing the notification of 2019. There are also similar provisions are there. Now the petitioner was also eligible to appear till 2019. Now, up into 2019, in 2020 and 21, Lord, the petitioner now become age barred. Because he has already.
In 20 itself, he had become age barred.
Yes, Milord.
Oh.
Now, since this new rule, this rule, Odisha Civil
he wants
Service,
to take advantage of that.
Yes, Milord. That is not permissible.
All right.
But my lord, for necessary.
It is not applicable to Odisha Judicial Service rules.
My lord, the question is whether the GA department notification is applicable to the judicial service.
No, that's what he's saying. He says the recruitment happens under the separate set of rules.
Yes, Milord.
But my lord, the fixation of upper age limit rules has specifically stated that it will be applicable to the civil post, my lord. And being a judicial officer, there is an employer and employee relationship.
No. That's stretching because there's a separate set of rules for judicial service.
Yes. Milord, in fact, I will just clarify another point here. Rule 41 is there in the OJS rules. That they says that the provisions of rules 12, 13, 14, 15, 16, 17, 18, 19, 20 of Odisha Civil Services Classification, Control and Appeal Rules 1962 and the provisions of the Odisha Service Code shall mutatis and mutandis be applicable to members of the service of power.
Not the upper age fixation.
But this rule is not included in this.
But my lord, that is with regard to superintendents, which is after the recruitment. But this is my lord.
No, sir, not ipso facto, it will not get applicable to this.
But my lord, for in page 14 lordship, therefore necessary action, the GA department has forwarded this notification to the High Court for proper action lordship.
No, but the High Court rules are a different set of rules, sir. And those have not been amended.
Yes.
You say recruitment to the Orissa Judicial Service happens pursuant to the Orissa Judicial Service. Just give me the full title.
The Odisha Superior Judicial Service and Odisha Judicial Service Rules 2007.
Odisha Superior Judicial Service and Odisha Judicial Service Rules 2007. Full stop. Under rule?
Rule 18, that the eligibility criteria is there under Rule 18?
No, the upper age criteria.
Yes.
It's fixed under Rule 18 of the said rules. Yes. Full stop. Paragraph. The contention of the counsel of the petitioner that a GA department notification dated
11
January 2022 enhancing the upper age limit for posts under the state government, for civil posts under the state government, for recruitment to civil posts in the state government should ipso facto apply to the OJS as well is not tenable for the simple reason that the rules applicable to recruitment to civil posts in the state government do not ipso facto become applicable to the OJS. Stop. In particular, Rule 44, is it?
47.
Rule 47.
Relaxation to
of the OSJS and OJS rules, 2007, which talks of relaxation, requires the government in consultation with the High Court to consider it expedient to do so. Stop. In the present case, it has not been found expedient.
Page
For
34.
such relaxation to be extended. Stop. It may also be noted that under Rule 41 of the OSJS and OJS rules, while certain provisions of the Orissa Civil Services bracket classification, control and appeal bracket rules 1962 and the provisions of the Orissa Service Code have been made applicable. The Orissa, which is that rule?
My lord, Orissa Civil Service fixation of upper age limit amendment rules 2022. Page 13.
Orissa fixation of upper age limit rules and the amendments thereto have not been made applicable to the OJS and OSJS paragraph. The court therefore finds no reason to interfere with the order dated 28/2/2022 passed by the Law Department, whereby the petitioner's representation for enhancement of the upper age limit for OJS has been rejected. The petition is accordingly dismissed.
Supplementary list for admission, item number 16.
Well, I pray for item 11, my lord. I pray for item 11, my lord.
So you just have to wait, sir. We have crossed that.
My lord.
Please wait till the end of the board. Yes.
My lord.
Supplementary for admission, item 16.
None appears dismissed and not prosecution.
Supplementary list, item number 17.
May I please, your lords?
Yes.
Item 17, my lord.
Yes, please.
Here, my lord, the petitioners are Sarpanch of 5 Gram Panchayats, my lord. Their prayer is for segregation of 5 Gram Panchayats from Paikmal block and their amalgamation with Padampur block, my lord. Paikmal is situated 40 kilometers far from the Gram Panchayats of these petitioners, my lord. Whereas Padampur is situated only 15 kilometers far from their Gram
So one
Panchayat.
set of villages, it will be helpful, for another it will not. So we cannot
Your lordship may kindly
interfere
turn to
with these
page.
decisions, sir.
Yes, my lord. There was an inquiry, my lord. Earlier, the petitioners had filed another writ petition PIL, my lords. In that PIL, this honorable court directed the opposite party number 2, that is Collector Burger, to make to
So
dispose
the
of the
challenge in
representatives.
this, the challenge in this petition is to a notification of 2012, correct? What you have challenged in the present petition,
My lord.
is a notification
Yes, my lord. That
of
is,
2012,
yes, my lord.
which is 10 years ago.
Yes, my lord.
So after 10 years, we are not going to quash that notification, sir. You have not stayed that notification. Have you stayed it?
No. Because it is as it is, my lord. The Tahsil office is still now,
No,
my
no.
lord.
Answer
Yes,
the
my lord.
question. Have we stayed this notification?
It was stated in the earlier writ petition PIL.
Sir, in this writ petition, have we stayed this notification?
It was not stated. Rather, the
So the notification has been in force for 10 years now.
But your lordship may kindly see, my lord, Annexure 4 and 5, my lord. Annexure 4.
Yes.
In pursuance to order of this honorable court, my lord, the opposite party number 2 directed the opposite party number 4 to make an inquiry, my lord.
All that was
The
done and this
inquiry-
notification was
Yes,
issued.
it is true, my lord.
The proposed location of the headquarters is only 15 kilometers, which is convenient for the villages and public.
Correct.
The other, which my learned friend is claiming, that is 40 kilometers away. So factually, it's
All right. You
And-
say this is the second round of litigation
My lords, I have
concerning
to
the
submit-
petitioner's prayer that
And it, my lord, so 1 minute, my lord. They have also filed the count and they have admitted, my lord. They have filed the counter, my lord. And it is under active consideration as per the amendment taken in the counter, my lord. And it is in the department, my lord. PR department and Revenue and Disaster Management Department, my lord. Your lordships may kindly see the paragraph 6 of their counter, my lord. Paragraph 6, they have admitted and said that it is under active consideration because the petitioners have a genuine grievance, man.
All right. You say this is the second round of litigation at the instance of villages Lakhmara, Chandrapali, Saraikela, Badikata, and Bukuramunda, GP, regarding change of the Tehsil and block office from Padampur to Paikmal. Full stop. Earlier, the petitioners had filed writ petition civil (PIL) number 16399 of 2012, which had been disposed of by this court by an order dated
7/9/2012.
7/9/2012, requiring the collector, is it, or subcollector Padampur, to examine their representation, their grievance, and pass a fresh order. Full stop. Pursuant thereto, an inquiry report was called for from the subcollector Padampur. I requiring the collector Bargat too. Pursuant thereto, an inquiry report was called for from the subcollector Padampur, who informed the collector by his letter dated 11/12/2012 as under. Reproduced from page 17, paras 2, unnumbered, para 2, 3, and 4. On the above basis, full stop. As a result, the petitioners have again come before this court. No, you say the petitioners then filed a representation on 2nd April 2013, reiterating the demand, and then have filed the present petition, questioning the notification dated 1st August 2012, whereby it was informed that the collector Bargat had approved the proposal for reorganization of the territorial jurisdiction of certain tehsils, and in terms of which the tehsil headquarters would be at Padampur. During the 10 years of pendency of the present petition, there has been no stay granted of the aforementioned notification dated 1st August 2012. Stop. A reply has been filed on behalf of the opposite parties, inter alia pointing out that while the Padampur tehsil headquarters is only 15 kilometers away from the aforementioned 5 GP areas,
Para 6.
the Paikal tehsil headquarters would be 40 kilometers away. Full stop. Further, there is only one all-weather road from the above GP areas to Pikemal, which goes via Padampur. Full stop. As a result, people of the localities would have to cover a longer distance to reach Pikemal than to reach Padampur. Paragraph. Having heard learned counsel for the parties, the court is not satisfied that any ground has been made out for interference with the notification dated 1st August 2012. Full stop. There are supposed to be satisfactory reasons why the petitioner's prayer that the headquarters should be shifted to Pikemal, is not even feasible. Is not feasible, and therefore cannot be acceded to. The petition is accordingly dismissed.
Supplementary list item number 18.
Urgent copy, my lord.
Supplementary item 18.
None appears dismissed.
Supplementary list item number 19.
19, your lordship permitted to withdraw.
Counsel the petitioner seeks leave to withdraw this petition. Dismisses withdraw.
Supplementary list item number 20.
My lord, on behalf of Bhikken Nayak, let it come next week, my lord. He is ill today, my lord.
Just tell us what the matter is about, sir.
I have no file, my lord. He telephoned me. He is
Let us see what the matter is.
And in the hospital, my
We'll
lord.
examine it, sir. We'll examine it. Regularized in the post of bench clerk 1, the date of joining. The man is already retired now. 7 years on 2013. Now he must be 65. What is the order passed here? No counter has been filed.
Well, in fact, he has submitted a representation on the annexure 4 to the opposite party number 1.
All right.
Submit direct
Petitioner's representation dated 14 March 2013 will be examined by the District and Session Judge Naigad, and a reasoned order shall be passed thereon not later than 9th May 2016 and be communicated to the petitioner not later than 16th May 2022. The court clarifies it has not expressed any view in the matter. The petition is disposed of.
Supplementary list item 21.
Item 21, the petitioner has already been died since 6 months ago.
Counsel, the petitioner states the petitioner has already died. The petitioner has been rendered instructions to the post office.
Supplementary list item number 22.
My lord, I may be pardoned to interrupt, my lord. My lord, a matter has been skipped, my lord, due to some net problem.
We'll call it again, sir. You just wait for the list to be over. Yes.
Milord, one minute. I may be pardoned, Milord. Milord, we were appearing for the opposite party, private opposite party earlier, but after the takeover of the company, Milord, there was a NCLT proceeding and restructuring. They have taken back the file. So the request has been made in the morning by the concerned legal department. They want to engage a new lawyer.
No, in which matter are you appearing, sir?
Milord, 22, both the matters, our name is appearing.
No, but the petitioners have to first make there's no one appearing for the petitioners.
No, my problem is that we are no more representing in the matter.
No, you are for the opposite party, sir. If nobody is appearing for the petitioners, let us first see if the petitioners are there.
Milord, that's correct.
Who's for the petitioners in 22? All right. None appears for the petitioners. Dismissal, non-prosecution. All three matters.
Supplementary list item number 23.
May it please your lordships. This is a PIL instituted by the Registrar Judicial. My late learned senior was appointed as amicus curiae in this matter.
What was the matter about?
This relates to the price of raw silk, in the state of Orissa. and the lack of support by the government in providing a minimum support price for raw silk, leading to a lot of weavers, traditional weavers, leaving the profession of weaving and joining as laborers. Your Lordship was pleased to entertain this wide minutes of the meeting dated 20th of November 2013 of the Honorable High Court PIL Committee.
All right. Mr. Das, either we have to have an updation because there's no counter affidavit apart from the NHDC's counter affidavit. And that's a very short one of 3rd March 2014. You see, this petition had been entertained on the basis of a. This shows the. News article published in the Telegraph on 13 November 2013 regarding non-availability of raw silk for the traditional weavers in the state. Full stop. Pursuant to the notice issued, a counter affidavit was filed by the National Handloom Development Corporation Limited on 3rd March 2014. Stating inter alia that explaining inter alia the system of supply of yarn through raw material banks and primary weaver cooperative society depots. Stop it stated.
I'm sorry, the link got disconnected. 23 minutes.
Yes. The inter alia it is stated that no complaint has been received from any corner by the NHTC that yarn is not available in loose form for the requirement of handloom weavers. Paragraph. In view of the above affidavit, the court does not consider it necessary to continue the present petition. To stop this will, however, not prevent any affected weaver cooperative society from approaching the court for relief if the problem persists.
Supplementary list item 24.
Obliged.
Right.
On behalf of Mr. Raigar, no instruction.
No instructions. All right.
Supplementary list item 25.
No instruction.
All right. No instructions.
Supplementary list item number 27.
No instruction.
No instructions.
Supplementary list item number 28.
Lordship, in this matter, we have received the counter few days back. Lordship may give us 2-week time to file a rejoinder.
No. What's the matter about, sir? This is 2015 matter. What is it about?
Lordship, it is about the inaction of the opposite party number 3, not implementing the order of the appeal, Lordship.
No, but these are not matters for a writ petition, sir.
Lordship will file a rejoinder, Lordship.
No.
1 week time.
No, sir.
What matter has been considered? I have in the stated in my counter affidavit, all the refund has been issued and adjusted against the assessment year 2009-10.
All right. It just shows the paperwork. The counter affidavit is not here scanned.
Lordship, the refund application was for 15 lakhs, Lordship.
Para 2 and para page 2.
The grievance in the present petition is about appeal effect not being given. The order is passed in favor of the present petitioner by the income tax, appeal not being given by the income tax department pursuant to an appeal order dated 10th April 2014, passed by the Commissioner of Income Tax Bracket Appeals, Cuttack. In response to the petition, the counter affidavit has been filed on 7th March 2022. Inter alia stating as under reproduced para 7A to A. Stating as under actually para 1 A to A and para 7 B to B. In view of the above explanation, no further directions are called for. The petition is disposed of.
Supplementary list item number 29.
None appears dismissed.
For item number 29, I pray for Passover, my lords.
All right.
Supplementary list item number 30.
My lords, on item number 30, there's a change in counsel for the petitioners, my lord. I have already filed my wakalatnama. It may kindly be taken on record.
All right.
That's a case, Lord, item 30. Lord, was filed in the year 2016, and there the apprehension was for containment of dengue in the area of Badbil municipality. And we have also filed a counter.
My lord, I know item number 30 on behalf of Dinesh Kumar Mahanti, no instruction.
Whom are you appearing for, madam?
My lords, for the petitioner here, my lords.
No, there are two petitions here.
Sadanand Sahu, my lords.
Sorry?
Sadanand Sahu, the main petitioner.
Nice, he's referring weekly list perhaps.
No, I think you're on a different list, madam.
What Sarita is mentioning, that is item 35, Lord. I'm also there in 35.
All right. In item 30, the petitioner states he has no instructions, dismissed as such.
Supplementary list item 31.
Pardon to mention, my lord. My lord, item 29, we don't have any instruction.
All right. 29, no instructions. Disposed.
Much obliged.
But somebody asked for a Passover. Which is this item 29? Which is your petition number, sir?
My lord.
What is the petition number in which you're mentioning?
Millards, I was appearing for the OPs. My senior was to appear in the matter.
No, OP. The counsel, the petitioner himself says no instruction, sir.
Millards, at that point of time, no one appeared at 29. For that very reason, I sought for a Passover.
No. You should first of all say whether you're for the opposite party or for the petitioner. You can't simply ask for a Passover. The counsel, the petitioner now says he has no instructions. All right.
Apologies.
Dismissed. Yes.
Supplementary list item 31.
My lord, item 31. Some of petitioner and opposite parties has been died. So I will file the substitute.
No. Tell us what the matter is about.
PIL matter.
Correct. But tell us what it is about.
My lord, actually, I am on behalf of Mr. Anjan Kumar.
We are not adjourning, madam. And this is not to be taken so lightly. You don't appear before this court without a paper book. Don't take it so lightly. Just because somebody has sent you to the Chief Justice's court to ask for an adjournment, you don't come like this. Please take it seriously.
All right. I will file the substitution.
No question. Where is your paper book?
Actually, I contacted one petitioner.
What
He
is the
told-
matter about? Tell us what the matter is about.
Actually, I am new, my lord.
No
so
question
I-
then. Don't take it so casually, please. You're not just walking into some post office. This is a high court. Please take us seriously. Yes. Who's for the other side?
Opposite party 9, Lordship. B. Bhuyan and Associates.
Yes.
The case was that, my lord, for changing the kisam of the disputed land from Gharabari to Jalashay.
All this, there are statutory remedies for all this. You say for the prayers made in the present petition, there are sufficient statutory remedies which can be availed of by the petitioners in accordance with law. Consequently, the court is not inclined to entertain this PIL. It is disposed of.
Supplementary list item 32.
Item 32, both the cases are in process.
Counsel, the petitioner states that these petitions have been rendered defectuous. They disposed of as such.
Supplementary list item number 33.
33, your lordship, on 14/3/22 was directed lease the item 33, your lordship directed lease the matter on 30 June 2022 on the ground that this takeover by the Tata Long products. So your lordship fix all the matter on 30 June 2022.
What's the date?
30 June 2022.
All right. List on 30th June 2022. All right. All these matters.
Mr. Parija is appearing for the
I am appearing here, my lord.
All right.
My name is Amit Patnaik, my lord.
All right.
Supplementary list item 34.
Item 34 can be taken on next week, my lord.
No. Tell us what the matter is about, sir.
This matter regarding appointment of junior copyist under Kendrapada Justice, my lord.
Yes.
And Dr. Jekalenka will argue the matter. He is in busy in Baravati Stadium for arrangement of cricket match. So kindly be taken on next.
Why don't you take this as an opportunity? Why don't you argue?
I'm not ready, my lord.
If you are ready with the matter, you can argue. You can then tell Dr. Lanka, sir, I went and argued. The Chief Justice allowed your petition.
Can be taken on.
Would he not be happy?
I will argue, my lord. Next week.
Will he not? No. Will he not be happy if you tell him, sir? Although you are in Baravati Stadium, I prepared the matter. I argued. The Chief Justice's bench has allowed the petition. Will he not be happy? Will he be happy or he'll be sad?
Happy, my lord.
He'll be happy, no? You don't want to make him happy.
Next week I will.
No. Why next week? Why don't you make him happy today?
I'm not ready, my lord.
No, you should make him happy today, sir. Today is a very good day for this matter. Nobody is disturbing you. You can relax. You're not in Baravati Stadium. Are you supposed to be like cricket today? No. You should take it as an opportunity, no?
Next week, man.
Dr. Lanka sent you with a brief. Should you not get into it? We'll help you get into it. Come read the prayer class. Come. Open the paper book.
Person to advertisement under Annex 1, page 14, dated 28/7/2018, for filling of the post of junior clerk copyist. Total post to 7. Your category belongs to 2 posts. The petitioner belongs to your, my lord. The petitioner applied in time, and after successfully in the written test, the petitioner's name finds place at serial number 2, my lord, under Annex 5, page 34, my lord. Prasant Kumar Das, your category, my lord.
See, inadvertently, they showed 2 vacancies for UR. There were no such vacancies. What is saying, Mr. Jointer? He says they could have issued a corrigenda. All right. Dr. Lenka is stated to be in some personal difficulty today. List on 12th April.
Supplementary list item number 35.
May I please, Your Lordship? Lord, there are 2 petitions. One is led by my learned friend Sarita, and I am in the second petition. In the second petition, my Lord, let us start the first petition because mine is in regards to the transfer, where I say the transfer is not in accordance with the rules. I think the first matter is led by Sarita.
May I please, Your Lordship? My Lord, in the first matter, the brief has been handed over to
She's there.
The petitioner. So the name of Mr. BP Tripathi and associate may be
deleted. The name of BP Tripathi and associates is deleted. Ms. Sarita Panda. Sorry. Ms. Sarita Panda is now appearing for the petitioners. Yes, madam.
Malas, first of all, I'm very sorry, Malas. I misheard the item number last time.
No, not a problem. Tell us.
My lords, I have just appeared my Wakalatnama in the matter. It may kindly be taken on record. And my lords, there were 2-3 instructions that were given on 22nd/11/2021, the last date of hearing.
Right.
First is the amendment cost title was to be filed, including opposite 6 and 7 as a party. My lords, I need some time to file it. I'll be filing it within 3 days.
All right.
And my lords, one more request is I am not very sure if the copies have been served. If not, I'll serve it again and reply if any may be served to me.
All right. So this is IA 8892.
My lord, it's the writ number.
No. The IA number. Or you have yet to file it?
I'm yet to file it.
I see. Counsel for the petitioner states that she will be filing an interlocutory application.
My lord, I'll be filing a amendment cost title.
All right. To amend the cost title to implead opposite parties 7 and 8, 6 and 7. 6 and 7. Who are they? 6 and 7?
My lords, it will be
Assistant Director, yes.
Oh, as per the as per the order dated. (22/11/2021). Stop. At her request, list on. We'll keep it for 27th April. If you file your application, we'll come up with that. All right.
Yes.
All right.
Second matter, I am there.
All right. We'll take it up on the same date, sir.
Then it can be little 2-3 days after because I want to personally come and
All right.
because since I thought today is our holiday, so I thought I
Right. 11th May, sir. 11th May.
I'll be grateful, my lord.
All right.
Really, at least I can wish happy Holi to both of us.
All right. In fact, both of you should be here physically then.
I'll be love to. If I get opportunity, my lord, I'll love to come to my own.
All right. All right.
I'm grateful, my lord. I must wish your lordship happy Holi.
Much grateful.
Happy Holi. Yeah. Happy
Thank
Holi.
you. Thank you. Both of you.
All right.
Pass to matter item number 13.
11, my lord. I pray for 11.
Okay. 11th May. All right.
Item 11, my lord.
Item 11. Sorry. Okay. That's nice.
Item 11.
my lord, the present petitioner, previously he was working under the company of the opposite party number 2, my lord. And the opposite party number 2, when he did not release the pending dues of the present petitioner, he took the shelter of the opposite party number 3, my lord. And opposite party number 3 passed an order, that is annexure 1, page number 16, 29,000 award, my lord.
59,000.
Page number 6, my lord. 59,000. Sorry, I'm 59,000, my lord. Then after the opposite party number 2 took the shelter of this honorable court, and this honorable court has dismissed that petition, my lord, that is annexure 2, my lord, page number 7. My lord. Then the opposite party number 3, who is the Labour Commission of Orissa, he has wrote a letter to the collector Sambalpur to relation of the dues of Kishore Kumar Sar, the present petitioner, my lord, and to initiate a certified case, my lord, against the opposite party number 2, my lord. Then the present petitioner has repented repetition to the collector Sambalpur in that respect, my lord. That is annexure 4, page number 9, my lord.
All right.
Will the collector may be directed to?
Yeah. We say it appears that direction has already been issued to the Labour Commissioner Orissa by the collector. Sorry, direction has already been issued to the collector Sambalpur by the Labour Commissioner Orissa to resume the certificate case against opposite party number 2, that is Mr. Vimal Kumar Agarwal, Managing Director, Messrs. Dean Medi Pharma Private Limited, Kolkata. Consequent upon dismissal of writ petition civil 14896 of 2006 by this court on 5th January 2018. Paragraph. In that view of the matter, a direction is issued to the collector, Sambalpur, to revive the aforementioned certificate case for which purpose the matter will be taken up by the collector on 9th May 2022. The petitioner will appear with a downloaded copy of this order before the collector on that day for further steps to be taken in accordance with law. The petition is disposed of.
Hello,
Supplemental list passed or matter item 13.
Right, please, Your Honor.
Yes.
Here in this case, earlier writ petition was filed by the same petitioner challenging the notice under section 147 of the Act in WBC number 14369 of 2019, and this honorable court has been pleased to dispose of the writ application on 5/7/2021. Wherein I may draw your lordship kind attention to page number 50 and the internal page of 8 of this honorable court order in WPC number 14,000. And have a glance to page number 50 of my brief. At paragraph 20, while paragraph 19, consequently, this court is not satisfied that the petitioner has made out any case for interference by this court at the stage, that is the stage of issuance of notice. So at the time of issuance of notice, that writ petition was filed. Then while disposing of the writ application, this honorable court has para 20 may kindly be seen. Accordingly, while reserving the right of the petitioner to raise all it depends available to it in accordance with law in the reassessment proceeding, including right to cross-examine the deponent of the statement relied upon by the department, the assessment proceeding, this court declined to. So the court, this honorable court, has been pleased to reserve the right to cross-examine and to raise all issue relating to my defense. Unfortunately, what happened, Your Lordship, after this writ application has been disposed of, suddenly a letter was issued by the National Faceless Appeal Center requiring the status of the petition, writ petition, pending writ petition. That has already been complied.
But suddenly, without affording any opportunity to the assessee, the reassessment order has been passed ex parte by violating the scheme of the phase assessment proceeding also. Your Lordship, in this case, natural justice has been seriously violated. Further, in one penalty proceeding, your Lordship, 271 1C, the order has been passed prior to the date of compliance. It's very pathetic situation, Your Lordship. Your Lordship, the order has been passed ex parte without affording any opportunity cross-examine. Further, the impugned order in Annexure 1, Your Lordship, that has been passed completely based on the third-party information without any examination by the National Faceless Appeal Center. So my humble submission before Your Lordship, this assessment order cannot be sustained for any legal scrutiny. It should be liable to be quashed, Your Lordship. They have not informed. They have also not informed that in month of July, 30th July, they have passed the reassessment order without informing the petitioner. And suddenly they have issued the penalty order that to prior date of compliance, they have passed the penalty order, Your Lordship. They have not followed the due procedure and laid down by
This
the
5th July order passed by this court.
Yes.
Sir, this 5th July order.
Yes, sir.
Have you provided it to the department?
Yes, I have provided. They have kindly have a glance, Your Lordship. I have provided that.
When?
I will give it. On they have issued a notice to me to the petitioner on 15/7/2021. On 22/7/2021, I have filed a petition by enclosing this honorable court order.
So they have not referred to that in the 31st July order. They don't refer to our order.
Your Lordship, kindly have a glance to Annexure 4, page number 53.
No, that is okay, sir. In the 31st July order, Annexure 1.
Yes, Your Honor.
Have they made a reference to our court's order?
No, they have report.
Where is that?
Yes.
Where is that?
Yes. Last. Yes, Your Lordship, 39, page 39 of the brief. For page 39 of the brief and para 12, Your Lordship. It is brought on record that Honorable High Court of Orissa has passed the final order of assessee in writ petition number so and so, in which the Honorable Court has dismissed the assessee writ petition, the relevant extract of the order as follows. They have not quoted the para 20 of the this Honorable Court order.
About giving opportunity to cross-examine.
Yes, Your Lordship. That opportunity has not been given to me. And relying upon that untested third-party information,
notice who's for the department? Anyone appearing for the income tax department? All right. Notice be served on Mr. T.K. Satpathy, standing counsel for the department. Till the next date of hearing, no coercive steps shall be taken against the petitioner pursuant to the impugned reassessment order dated 31st July 2021. Reply be filed within 4 weeks of service of notice. Joined up for the next date. List on 25th July.
Weekly. Weekly list, old matter, item number 1, CRA 94 of 2001.
This criminal appeal can be taken up next week, Lordship.
Why?
Can be taken up next week, Lordship.
Why? Carry on, sir. Why should we adjourn?
Next week, any date, Your Lordship.
No, why? There must be good reason, please. We're not sitting here only to adjourn cases. We are sitting here to hear cases.
There are 3 criminal appeals, Your Lordship. Criminal appeal number 94 of 2001, criminal appeal 191 of 2001, and there is another criminal appeal 804 of 2018.
Right.
In criminal appeal 94 of 2001, there are 15 appellants, Your Lordship.
Right.
In criminal appeal 191, there is 1 appellant. In criminal appeal 804 of 2018, there is 1 appellant. Your Lordship. They have been convicted by Session Judge Kandamal both under section 302 by 149, 452 by 149, 148 of IPC and sentenced to undergo imprisonment for life under section 302 by 149 of IPC, RI for 3 years under section 452, 149 of IPC, RI for 1 year for 148 of IPC. All the sentences are directed to run concurrently. Lordship, kindly see the paper book first. Lordship, reading the case of the prosecution that is available to Your Lordship to as page 33, Your Lordship. Briefly, the prosecution case is like this. On 11/11/1998 morning, one Pradeep Malik of village of deceased Chandrasekhar died in Barampur Medical College Hospital having suffered from some disease. His body was brought to the village for cremation was made. Thereafter, the villagers was held a meeting near the village well and held Chandrasekhar Pradhan responsible for causing death of Pradeep Malik by practicing sorcery. The meeting was ended in some disturbances. Then at about 9 p.m., thus said day, about 15 to 20% came from the meeting place, called Chandrasekhar, knocking the door, and some of them also forcibly entered into his house and dragged Chandrasekhar outside and assaulted him. Hearing the noise and sound, the brother of Chandrasekhar, who is a resident of the neighboring house, came out and found this accused person assaulting Chandrasekhar on the village danda, and after such assault, they dragged away Chandrasekhar towards the end of the village. In the night of Chandrasekhar did not return, and in the following morning, the family members came to know that the accused person has caused the death of Chandrasekhar by burning him in the pyre of Pradeep Malik. Then the younger brother of deceased Chandrasekhara, by name of Subhas Pradhan, went to lodge the affair before the police station, on the basis of which case was registered and the investigation was taken up. After completion of the investigation, this accused person was charge sheeted and case being committed to the court of session, they faced trial. Now the defense story, Your Lordship, as parathi. The defense pleads complete denial and false implication of political rivalry and enmity. The specific plea taken by the accused Vinod Naik, his brother accused Mata Naik, and the accused Gopabandhu Naik, that the deceased Chandrasekhar and his brother Subhas Pradhan has outed the modesty of the wife of accused Vinod, for which meeting was held in the village, and they were fined 1,001, and for the reason they have a grudge on the informant Subhas, robbed them and after other relatives in such false case. Accused Kalia has taken a specific plea that in the year 1992, the father of Gautam Pradhan and one Subhas Acharya were contesting for the office of chairman of local Gram Panchayat, and the informant Subhas Pradhan was campaigning for the candidate Subhas Acharya, but ultimately Gautam Pradhan was elected. Since then, there was a party faction in the village, and for that reason, the informant falsely robbed him in this case. The specific plea of the accused Balleswara is that because of the defeat of the candidate of the informant in the aforesaid Panchayat election, and as the meeting regarding outright modesty of the wife of Vinod Naik, the informant and the deceased brother Chandrasekhara was presided by him, accused Balleswara, and imposed penalty of 1,001. On the deceased of the brother, they has taken falsely implicated in this case. In order to prove the case, Your Lordship, the prosecution has examined altogether 7 witnesses, Your Lordship. Out of them, 1, 2, and 3 are the relative witnesses. 1 and 2 are the younger brother of deceased Chandrasekhar, and PW3 is the wife of Chandrasekhar. PW4 and 5 turned hostile. PW6 and 7 are the investigating officer, Your Lordship. Then inner defense also examined 6 DWs, Your Lordship. The star witness of the prosecution is PW2. PW1 and there are 3 eyewitnesses, PW1 and 2.
But PW1 and 2 have seen the first part of the occurrence, that is, they assaulted the deceased on dander and taken away to the cremation ground. They have not gone to the cremation ground, but PW2 said, I have seen the occurrence from the on the cremation ground. Lordship, I will take you to your Lordship to PW1 first. His evidence is available to your Lordship as page 123 of the paper book, your Lordship. I know all the accused person present and the duck. They are my co-villagers. The deceased Chandrasekhar Pradhan is my elder brother. The occurrence took place on 11/11/98. The elder brother of accused Dilip Kumar Malik died in Medical College Hospital, Berhampur, and his dead body was brought to the village and was cremated. On the day of occurrence at 9 p.m., the accused person conveyed a meeting in the village near Villageville. It was debated in the meeting that the deceased elder brother Chandrasekhar Pradhan was practicing sorcery and killed Pradipta, the elder brother of accused Dilip Kumar Malik. On that day, the deceased brother was sleeping in my house. I was also sleeping in my house. My house and the house of my deceased elder brother are adjoining to each other. On that night, after meeting was over, the accused person came in a body being armed with lathis, bodies, stones, and they broke open the door and the house of the elder brother. On hearing the sound, I came out of the house and saw the accused person assaulting the deceased brother by giving him kick and lathis and stones and outside of his house. At that time, in front of my house, electricity lamp was burning in the electricity pole in front of Lordship. Kindly mark this line. At this time, in front of my house, electricity lamp was burning in this electricity pole in front of my house, because I relied heavily on the presence of light, your Lordship. The accused persons was present in the gathering, and I name all the accused persons who are today present in the tub. Due to the assault, the accused person, my brother, fell unconscious. Thereafter, the accused person carried to the deceased, brought to the extreme north end of village. On that night, the accused person cremated the dead body of elder brother of accused Dilip, namely Pradipta. As the brother did not return home the night, I went to search him. Accused person threatened to assault me, so I came away. On 12/11/98 morning, I reported the matter orally to G. Udayagiri police station. Police reduced my person in writing and treated my report as a FIR. The contents of the FIR were read over and explained to me. Knowing the same, I seemed to be true and correct. I signed the FIR. Exhibit 1 is the FIR. Exhibit 1 by 1 is my signature. Cross-examination. I reside in Dubri Sahi. My Sahi consists of 50 to 60 houses. We are 4 brothers, including the deceased brother Chandrasekhar. To the north of my house, there is house of deceased brother Chandrasekhar. The house of our younger brother is Gurudev, is situated in the north. Our another brother Joydev is serving in the defense, and he does not stay in the village. I reside with the family consisting of myself, my wife, son 60 years, and my daughter is 17 years. These are the independent witnesses, your Lordship. They have seen the occurrence, but they have not been examined.
There is, how were the accused arrested, and was there any TIP?
No, my lord. No TIP period was held.
This witness doesn't identify any of them in a TIP?
No, my lord. They were named in the affair, so there is no need of any.
Oh, they all named the affair?
All named in the affair. There was electricity in my house. It is not a fact that there was no electricity supplied to my house. On the date of occurrence, there was no electricity connection to the house of the deceased brother Chandrasekhar. The date of occurrence was a dark night. On the night of occurrence, electricity bulb was burning on the veranda, and also there was a light in front of my house. Had there been no electricity light on that night, I could not have identified the accused persons. That is rest parts. The accused persons assaulted deceased brother just in front of my house. The village road will be distant to 50 meters from our house. My wife, my son, my daughter, all have seen the assault, but they were not examined on the deceased brother Chandrasekhar by the accused person on that night. This part is not that important, your Lordship. I came to PW3, your Lordship. PW2 is the star witness. I will come to his evidence later, your Lordship. Lordship, kindly to PW3.
Yes.
that is available to your lordship as 136. I know all the accused person present in the dock. They are my co-villagers. PW1, who is the informant of this case, is the younger brother of my husband. PW2 is also a younger brother to my husband. About 2 years back, the winter night, while I was sleeping with my son Brajakanta and my late husband Chandrasekhara at about 9 p.m., accused person Kalia, Chandrasekhara, Matta, Dilip Kumar Malik forcibly entered inside our house, breaking open the door and caught hold of my late husband and assaulted him, dragging him outside the danda. At that time, PW1 and 2 were present in our danda in front of our house. The accused persons being armed with kati, thenga, lathi, assaulted my husband. When I followed my husband to the danda side, I also assaulted the accused person, for which I fell on the ground. Thereafter, the accused person, after assaulting my husband, carried away towards the Tolasai of our village, cross-examination. In the night of occurrence, when the 4 accused persons noted above forcibly came inside the house, breaking open the door, a debris light was burning. No debris light was seized by the police, your lordship. But there was street light in the danda in front of our house. In the debris light, I identified the accused Mata Naik, Chandra Pradhan and Dilip Kumar Malik. It is not a fact that I have not mentioned the name of Dilip Naik in the statement before the police. On the next day of the morning of the occurrence, G. Udayagiri, I visited our house. I showed them the debris lamp. Police saw it, police took it, and after 2 days returned it. Due to the assault by the accused persons, even though I fell down, I did not lose my sense. It is not a fact I have not stated before the IO that the night of occurrence, I saw PW1 and PW2 standing outside the house of the village danda. After I assaulted, I fell down. I myself stood up and nobody carried me inside the house. When I stood up, I saw the accused persons already carried away my husband, crossing the village well on the night of the occurrence. My neighbors, namely Beda, Baji, and Lutki, have also seen the assault of my husband. I recognize the accused persons in the danda by the street lamp, your lordship. Due to the fall, I have very minor injury on my forehead. Police had seen the injury. It is not a fact that on the night of occurrence, no street electricity light was burning in front of our house. It is not a fact that I have not seen the accused.
So she's also talking of the electric light only.
Your lordship. Lordship, kindly at this time, young sir, turn to DW2, your lordship. He is the SDO of that.
Yes.
DW2, your lordship. Defense witness number 2 is the SDO, is a government officer, your lordship. I have that evidence available on 157, your lordship. Page 157. I have been working as SDO electricity from December 99, stationed at G. Udayagiri and continued as such. We maintain register regarding supply of electricity to different panchayat. Today, being directed by the court, I produced the register. On 11/11/98, there was no street light supplied by our department to village Dugripari under the Kalinga GP. We also maintain a register regarding supply of electricity to the village of domestic consumption. From the concerned register, I saw that on 11/11/98, no electricity was supplied to one Subhas Pradhan, Gurudev Pradhan, Chandrasekhar Pradhan. I filed the concerned register. Exhibit B is the register relating to supply of electricity to the street of village. Exhibit C is the consumption of electricity.
1 minute.
To domestic.
Yes.
Cross-examination party, your lordship.
Yes.
Exhibit B relates to the supply of electricity to the village street for the period of May 2000 till date. I cannot say how many villagers are there under the Kalinga Gram Panchayat. I cannot say how many.
So how does the trial court deal with this?
My lordship, I will come to this on page para 21. Lordship, kindly cross-examination part, para 2. Even now, there is no street light in village Dugri.
I know. Even in 2000.
The trial court deal with it in para 21 of the judgment, your lordship. Lordship, that is available to your Lordship in page 46 of the judgment. The Lord and Counsel for the defense has vehemently contended that according to PW 1 and 2, they saw the recognized the accused person by state electricity light. What the defense evidence would show that during the relevant period, no state light provision was made in the occurrence village, and hence identification of the accused person in dark night is totally impossible, must be disbelieved. The defense has put a suggestion to PWs regarding non-existence of street light in their village and non-supply of electricity to their houses during relevant time. On this point, the evidence mainly relied by the defense is the DW2, who is the SDO of electricity of G. Udayagiri subdivision. The occurrence of the village is admittedly within the subdivision. The evidence of DW2 is that on 11/11/98, no street light was supplied to their department to the occurrence village Dunguri Pari, and the support of it, he produced the connected register marked Exhibit B. Similarly, he reported that during that time, no electricity was supplied to the house of PW 1, 2, and the deceased Chandrasekhar Pradhan, and in support of he filed the connected registered Exhibit C. But in cross-examination, he admitted that Exhibit B relates to the supply of electricity to the village state for the period from May 2000 onwards. My lord, he is saying till now there is no electricity.
He says even in 2000 there's no electricity.
Similarly, his evidence cross-examination is that as per government instruction field, my lord, this part is merely assumption. From evidence in cross-examination, in that as per government instruction, free electricity was being supplied to the house of members of scheduled castes and scheduled tribes by 1 year. That Exhibit C does not relate to free electricity supply to members of that category. That PW 1 and 2 and their brother Chandrasekhar were Adivasis. Where from this Lordship, the Sessions Court got it? They are Adivasi. If the Sessions Court is, Lawrence Judge is saying they are Adivasi, they should produce their caste certificate.
So apart from the two eyewitnesses, there are any other eyewitnesses?
The other main eyewitness is PW2, Your Lordship.
Right.
PW2, Your Lordship, kindly have a glance to that. PW2. That is available to.
No, so 2 and 3 are the only two eyewitnesses.
3 eyewitnesses. 1, 2, and 3. 2 is the star witness. Right. I have not read 2. Lordship, if you permit, I will read 2. I know all the accused person identified in the dock. They are all my co-villagers. PW1 is the informant of the case and my old elder brother. This is Chandrasekhar, was also my elder brother. My other brothers is Joydev Pradhan is also serving at defense. The occurrence took place on 11/11/98 at night. At that night, I was present in my house. The house is 4 brothers were adjoining each other and one place facing the village road. On that night, on hearing the noise and pushes given to the door of my elder brother Chandrasekhar, I came and saw the accused person assaulting my elder brother. Chandrasekhar by lathis and sticks, and they were also giving kick blows.
So none of these eyewitnesses, all are related witnesses. None of them is injured.
No, they are not injured.
So 1 and 2 are brothers, and third is the sister-in-law. Wife. Sorry. All right.
The accused person is telling Salaku Jibanere Maridio. When due to the assault, deceased brother fell unconscious. Thereafter, the accused persons took away my deceased brother and dragging him, they took him to the northern extreme end of the village. Our neighbors, namely Beda alleged Binayak Sahu, Viji Sahu, and an elder brother Subhas have seen the assault. Since the accused person threatened the assaulter by lathis, we did not follow them. After some time, after the accused person took away deceased elder brother to my village was calm and quiet. I went to search of deceased brother, though barry lands and bushes. Then I saw the accused person had kept my deceased brother at the cremation ground of our village at a place where they have cremated Pradipta and my brother accused Dilip during that time. I saw by concealing my presence behind the betel shop of cabin of Beleswar, Kohara, that my elder brother was feeling restless and he was lying in the cremation ground. I heard the accused person talking among themselves not to spare elder brother and born alive, and they were telling that in case of my brother would be saved, he would escape, and they all will be arrested by the police. The funeral pyre of Pradeep was not extinguished by then. The accused persons threw my deceased brother on the pyre and burned him alive by arranging woods, meadows, and fence of Dilip. Seeing this situation, I trembled and concealed myself on the rest of the night. In the morning, I narrated the incident to my elder brother Subhas. Subhas never told that the PW2 stated all these things to me. Who went to lodge the FIR in G. Udayagiri PS. My lord, the cross examination is very important, your lordship. In every sentence, he's saying, he's changing his sentence, his version, your lordship. On that night, I concealed my presence in the backyard of my house. In this sentence, he said, on the night, I concealed my presence on the backyard of my house. On that night, my wife and children were present in the house. My lord, he saw the incident, came to the house. Why he did not went inside his house? Nobody else saw him. I concealed myself behind the bushes of backside of my house. 2 and 3 kilometers away from my barry, the jungle started toward the west. Again, 2 kilometers away, the east, there was calling a jungle. On that night, after seeing the incident, I came to the backyard of my house. Then I went inside the jungle, and then in the early morning, I came to G. Udayagiri. In first sentence, he says saying that I concealed myself in the backyard of my house. In second sentence, he is saying I went to the jungle. I came to G. Udayagiri PS, and then my brother Subhas and I came to G. Udayagiri PS, and by then my brother Subhas has already arrived at the police station. PW1 never stated that. At the time, at the police station, I have told my police officer, the present, that I have seen the incident from beginning to the end and assault of my deceased brother to the accused persons, and later burning him alive, putting Pradeep on the funeral pyre. Police accordingly recorded my statement at PS. Nobody stated. PW6 and 7 are investigative officers. They have not stated that, my lordship. And myself and my brother PW1 came back home. Your lordship said, then I narrated the incident, whole incident, to my brother Subhas early morning in the backyard of my house. He stated that I went to the jungle from the jungle I straight went to the G. Udayagiri PS. And in this sentence, he is saying, I narrated about the whole incident to my brother Subhas early morning in the backyard of my house.
How come there are 15 accused? 4 of them took away the deceased, right?
All were present. They are saying all of them were present in the cremation ground. And after that, they...
So using 149, everybody's been convicted.
They have not stated that who is holding what weapon, and who is holding kati, who is holding lathis. They have never stated that. And he went to G. Udayagiri PS, and after backyard of my house, and there was present and hearing from me.
So all 15 are identified by this one electric lamp.
One electric lamp.
Extraordinary. What is going on? So does PW2 talk about electric light?
Electric light, your lordship.
How does he identify all of them? I think no question is put to him on the electric light.
No question was put to him. But your lordship kindly see, from the cremation ground, the police station is hardly 1 kilometer, your lordship. In para 9, he stated that the cremation ground of our village will be at a distance about 1 kilometer from Kalinga police station. Well, he came from the cremation ground, he came back to his backyard. Then after that, he went to the jungle for 3 kilometers. But he cannot go to the police station and say that, please save my brother, who is being assaulted by these persons, your lordship. Then your lordship kindly see.
So they were all, according to this person, they were armed with lathis only.
Lathis and kathis and
assault
stones.
was by hands.
And no dead body was recovered, your lordship. No dead body was recovered because he was thrown, according to the prosecution, he was thrown on the pyre of the. No,
but the ashes, was the DNA tested on the ashes?
No, nothing was that sort of conducted. Only chemical analysis of the bone.
No, so this 11th November 98, when did the police get the information finally?
No, police have not done anything. They have collected some bones and they sent it to for chemical examination. The chemical examination report is available to your lordship at page 176 of the paper book. The opinion is that the exhibit marked as egg are human bone and they are of male sex. They have not saying that what are the only things they do that. In that fire, the Pradeep was.
And Pradeep Malik's fire was also there only.
Also there.
Oh, so that we can't identify whose bone is which.
Suggestion was also given.
So no body at all recovered. I know. Apart from saying it is a male bone, they don't know whether it's Pradeep Malik's bone or this man's bone. After how many years was bail granted to them? When was bail granted to these accused?
Kalia Pradhan was he was absconded. He was filed his criminal appeal in 804 of 2008. He was not granted bail. Others granted bail.
But bail by this court?
By this bail was allowed to Mata Naik and others. Bail was granted on 7/7/2005, Your Lordship.
So that spent about 4 years in jail. In the trial court also, they were not granted bail. Were they granted bail in the trial court? No.
That I have to verify on the LCR. Your Lordship.
All right. Who's for the state?
Yes, my lord, I'm preparing for the state, my lord. My lord, out of three, my lord, 3 appeal, 2 are in the paper book and another, my lord, appeal that Kalia Pradhan, CRLA 804/2018, he, my lord, remained absconded, my lord, during 313 statement. Thereafter, he was apprehended after 18 years. He preferred appeal in the year 2018, and his delay was condoned and appeal is pending, my lord. So earlier, these 2 appeals were taken together, and paper book is in respect of 2 appeals. And in both the appeals, my record shows that both are granted bail in both the cases. So for the merit of the case is concerned, my lord, in this case, 3 witnesses are there in the eyewitnesses out of 7 prosecution witnesses. And my lord, informant at the cost of repetition, I would like to, my lord, to the lordship kindly have a glance to the FIR, my lord, first. The FIR occurrence took place in the night, and in the very next day, FIR was lodged in the police station. So what my friend was submitting that the PW2 would have reported the matter very promptly. That is, my lord, in the very next morning, my lord, FIR was registered. FIR was occurrence took place on 11/11/1998 at 9 p.m. in the night, and on the very next morning, information was received in the police station. FIR was lodged.
No, morning when?
Pardon?
What time of the morning?
In the morning, 8 a.m., my lord. And thereafter, my lord, in the FIR,
1 kilometer away, sir.
Pardon?
Police station is just 1 kilometer away.
My lord, say
if your own brother, just imagine, 2 of the eyewitnesses are brothers of the deceased.
Yes, 3
brothers can't go within 1 hour to the police station. They have to wait till next morning.
That, my lord, that presumption can be done, but on the next, my lord.
Is it natural? Your own brother has been carried away. The police station is 1 kilometer away. You will not go to the police station.
Because he has explained in the FIR, my lord. In the FIR, he explained that may read in the Odia. ରାତିରେ ଆମେ ଘରକୁ ଫେରି ଡରିକି ରହିଲୁ ଓ ମୋ ଭାଇ ଆଉ ଫେରିଲା ନାହିଁ ସକାଳେ ମୁଁ ଶୁଣିବାକୁ
No,
ପାଇଲି
to
ଯେ ମୋ
report to the police is one thing. See, what happens is your brother has been carried away by the mob, right? There is a mob of people. 15 people have come and carried away your brother. There's no one around threatening you. Sometimes what happens is 3 of the hooligans or 5 of the hooligans are left to continue to threaten the other brothers. That is not their case.
No.
All of their cases is the mob came and took away the brother.
The mob came to their house and started pelting stone, and thereafter, after assaulting, they took.
I don't know. Pelting stone is something you're adding now.
That is there. Pelting stone to their house.
No. Brother's house, not their house, sir.
My lord, the evidence of
We just read PW2. He heard the commotion outside his brother's house.
Yes, his brother's house, because their houses are adjacent.
Exactly. These brothers were not attacked. Just remember this. The attack was only on the deceased's house. The attack was in the house of the deceased.
Yes.
And the deceased was taken away by the mob.
And he says that in the night.
I'm just asking, is it natural after the deceased is taken away by the mob for these 2 brothers who remain in the village not to go to the police?
That my lord, in the night of occurrence, that is why they are saying that explain in the FIR that due to fear they could not.
Fear of whom, sir? I'm just saying, see, the villagers are, let us say the attacking mob, some 5 people remain to threaten these 2 brothers, I can understand. There's no one there to threaten them. If that was that fear, then how next morning they went to the police?
That your lordship can appreciate what is your lordship can appreciate. But thing is that they explain in the FIR that due to fear they could not.
We have to test. See, ultimately eyewitnesses have to be tested for the credibility of the evidence.
That is I am saying.
Trustworthiness and reliability.
It is up to your lordship to appreciate their evidences and to regarding the credibility of the.
You're taking the easy way out.
Of course, both the witnesses are their brothers.
All right.
And furthermore, but the evidence of the PW2 is the most important and the info.
What is the distance of the PS from the spot?
Distance from
Only
PS.
1 kilometer.
Well, it is around distance from PS direction is 9 kilometer. In the FIR it reveals that Dungurupalli 9 kilometer from northeast to the. In the FIR, lordship running page 65 in the FIR it is mentioned 9 kilometer. My lord got it direction and distance from place of occurrence is Dungurupalli. My lord got it.
Yes.
Running page 65. The FIR. In the column, it is mentioned place of occurrence is Dugudipari. Last in the FIR column, my lord, the first difference. Direction and distance from PS. 9 kilometer from the northeast to PS.
See, your brother is taken away. No.
In the cross-examination part, PW2 has stated in page para 9, the cremation ground of our village will be at a distance about 1 kilometer from the village police outpost.
There is an outpost.
Right.
The police station is one thing, police outpost is another. All right.
So, for my lord, the evidence of PW out of 3 witnesses, PW 1, 2, 3 are the eyewitness to the occurrence, as my friend has already narrated before lordship, my lord. And PW 2's evidence is, my lord, on the evidence of lordship will permit once again. Only I will want to praise the evidence of PW 2 because PW 2 has categorically stated regarding the. I will read there on the some relevant person. The date of occurrence is on 11/11/98 at night. On that night, I was present in my house. The house of the house of the 4 brothers are adjoining to each other at one places facing to the village road. On that night, on hearing the noise and pushes given to the door of my elder brother Chandrasekhar, I came out and saw the accused persons assaulting my brother Chandrasekhar by lathis and stick, and they were also giving him kicks and blows by hands. The accused persons were telling or using obscene language. Due to assault, my brother, deceased brother, fell unconscious. Thereafter, the accused persons took away my deceased brother by dragging him, and they took him to the northern extreme end of our village. Our neighbors, namely Bada alias Binayaka Sahu, is PW4. Of course, is an eyewitness to the occurrence. Subsequently, he turned hostile. And Baji Sahu and my elder brother Subhas.
So who,
PW1.
Baji Sahu is not even cited as a witness.
Baji Sahu has not been examined.
So the only
Two
independent witness
other
is Binayak.
eyewitnesses- Two other independent eyewitnesses were there. They turned hostile, my lord.
That's right.
Yes.
All right.
Since the accused persons threatened to assault us by lathis, that is why, my lord.
So no,
Since the
that is
accused-
not following them. So
I'm reading on.
all right.
Since the accused persons threatened to assault us by lathis, we did not follow them. After some time, after the accused persons took away that my deceased elder brother and the village was calm and quiet, I went in search of my deceased brother through Bari land and bushes. Then I saw the accused persons have kept my deceased brother at the cremation ground of our village, at the place where they had cremated Pradeep, the brother of the accused Dilip, during the daytime. I saw by concealing presence behind the betel shop cabin of one Baleswar Kaur that my elder brother was feeling restless and was lying in the cremation ground. I heard the accused persons talking among themselves not to spare my elder brother and to burn him alive, and they were telling that in case my brother would be saved or he would escape, they will all be arrested by the police. The funeral of Pradeep was not extinguished by then. The accused persons threw my deceased brother to the fire and burned him alive by arranging wood and madder from the fence of Dilip. Since seeing the situation, I trembled and concealed myself for the rest part of the night. In the morning, I arranged about the incident to I narrated the incident about the incident to my elder brother Subhas, who went to the.
This is not
went
what
and
Subhash
lodged the
says.
affair.
Subhash
So
does not
this
say
is-
about this man coming and narrating anything to him.
These things similar to this has been explained that PW he narrated the entire incident to the, because he is the person who has seen the entire occurrence, last part of the occurrence.
No, but Subhash does not say that this brother came and narrated to him anything at all.
Is similar yes. Because he is one of the eyewitness, he had has occasion to see the occurrence, the first part when his
We are
brother
now
was taken.
testing this man's statement that he went and told Subhash about all of this.
This evidence of PW1, my lord. Then I can. Thereafter, the accused persons carried my deceased brother to the extreme northern. On that night, the accused persons cremated the dead body of the elder brother Dilip, namely Pradipta, as my brother did not return home. On the night, I went in search of him, and the accused person threatened us to assault. So I came away. On the morning, I reported the matter to our police, reduced version of
So he should be saying
that, yes, that part is not there, that he came and on
Then-
his report, he lost the FR. That is
How
not
do you
there.
corroborate?
So for the
Therefore, the narration is not
no,
corroborated. right?
yeah, the sequence is that, my lord.
Now look at the cross-examination, the first line.
PW.
Same, PW2.
PW. On that night, I concealed my presence in the backyard of my house.
So that itself straight away knocks off everything. The man is actually saying in his chief examination, he went into the jungle, he kept looking, and here he's saying, I concealed myself in the backyard of my house. How do you believe this person?
No, what is similar? He is saying that, I'm explaining, my lord. He is saying that after that, on that night, I concealed myself in the backyard of my house. So he is saying that after that occurrence, he, my
Not
lord,
after that, sir. So
if you also could refer this line, but the
Anyway, you read on. There are other problems you have.
on that night, my wife and my 3 children were present in the house. I concealed myself behind the bushes in the backside of my house. 2 to 3 kilometers away from our body, the jungle starts toward the west. Again, 2 kilometers away to the east, they are the Kalinga jungles. On that night, after seeing the incident, I came to the backyard of my house, and then I
All
went
this
inside
coming to
jungle.
the backyard
So
of
he's
his
saying
house.
that-
1 minute, sir. 1 minute. This coming to the backyard of his house, he does not mention in his chief examination. All right. in his examination in chief, he's only talking about going into the jungle, looking
yes.
for his brother, witnessing the incident. No whisper of any coming and hiding himself in the backyard of his
is
house.
not there.
Suddenly, this backyard emerges. How is that?
Minor, this say my lord, minor contradiction. It's similar to obvious, my lord, because in such types of incident. But
All
he
right.
in the
All right.
in the
all right.
material particular, he stated that he after seeing the occurrence, he came and since due to fear, he could not. They could not lodge the FIR. On the next morning, his brother lodged the FIR. So this part, my lord. And at the police station, I have told the police officer present that I have seen the incident from beginning to end of the of assault on my deceased brother by accused persons, and later on burning him alive by putting Pradipta on the funeral pile. Police accordingly recorded my statement at PS.
So you're entirely relying only on this PW2.
Yes, my lord. He is the man. He is the
No. So you've given up 1 and 3 because they saw it on an electric lamp.
Yes.
And there's no electricity in that village.
Prosecution has mainly relying upon the evidence of PW2, who has in fact has seen the entire occurrence from beginning.
The problem with PW2, interested witness, not injured, and keeps contradicting himself. And one person is supposed to have named 15 people.
My lord, as your lordship knows, my lord, even conviction can be sustained on the solitary witness if it is believable and trustworthy.
He must be solid.
Yes. So
this man doesn't know whether he was in the jungle or he was hiding in his house. Within a few minutes, he's changed his version.
My lord, that line only. What your lordship is asking me that question, that he is hiding himself.
These kind of incidents you never forget in your life. Your brother has been taken away by a mob. Your brother is burnt on a pyre. Can you forget the details?
Details, my lord, he has given in the detail. My submission before
No,
lordship.
whether you were in the jungle or hiding yourself in the house, that you will not remember.
That part he has not stated in chief, of course. And but from the cross-examination, if your lordship will see only my submission before lordship only, that so far the participation of the accused persons in the cross-examination, nothing has been brought out in the examination PW2 to disbelieve his evidence. So far the participation of the accused persons, and that he has stated that all the accused persons were holding weapons. My lord, the charge is under section 147, 148 is there, my lord. So if your lordship know, my lord, charge under 147, 148, then 302 by 149 is there. Even, my lord, one person has participated in the mob to do a certain act, my lord, for committing offense.
Ultimately
In common
boils down to this. This is a dark night, right?
Yes.
So other two witnesses tell us it was a dark night. They are supposed to have identified all the accused by one electric lamp on a pole outside the house, right? And the electricity inspector comes and says no electricity was supplied to that village. Even in 2000, no electricity was there. This occurred in 98. Even in the year 2000, there was no electricity in the village. This is the electrical inspector telling the court.
SDO.
So those two witnesses are straight away knocked out. The two witnesses who are supposed to have, the other two eyewitnesses, who keep saying about electricity lamp, they are finished. In a dark night, if you can't identify 15 people, how do you identify 15 people in a dark night, sir?
Well, at this it is well at PW2.
Which is why you're heavily reliant on this one man, PW2.
PW2 and in the
fortunately for you, nobody asked him, how did you see 15 people?
That question has not been.
That's not there. If he had said that, this witness also.
Only one line is there that I know all the accused persons, and in the first line, Malad, he has said that I came out and saw all the accused persons assaulting my brother.
Safe?
And
so
all were
in
holding.
The same incident, there are at least 5 witnesses, 2 of whom were independent eyewitnesses and 3 were interested witnesses.
The independent witnesses that didn't support the prosecution case.
We are left with only one interested witness and one independent witness who turns hostile. The entire evidence relies now on one independent witness, interested witness, correct?
Yes, PW2.
Next Thursday. Next Thursday. All right.